You want me to use this? Ochir Dudley. And finally, Willis Echeza.
I'm present, my lords, my lady.
My lords, your leadership, given the large number of parties and their respective council, with your concurrence, my suggestion is that council appearing for the different parties introduce themselves for the sake of accuracy. I thank you.
My lords and my lady, I was waiting for the second petitioner, but in the matter for the third petitioner, my name is Muge, and I appear together with my colleague, Honorable Jen Njeri Maina.
Honorable who?
Jen Njeri Maina.
Good morning, your lordships, your ladyship. For the 4th to the 8th petitioners, my name is Ogada. I appear with my brother Sakimpa.
I'm present.
Thank you.
Good morning, my ladies, my lord. My name is Dek Wanjiru. I hold brief for Mr. Kibe Mungai. We appear together with Kibe Mungai for the 10th to the 41 petitioner, together with Mr. Ole Kamwaro, Mr. Nyamu, and Mr. Simon Boro. Equally well, my lady, my lord, for the 44th to 49th petitioners, the quorum remains as stated.
Your Lordship, my lady, my name is Morara Omoke, 43rd petitioner and counsel, and petitioner in E027 of 2024.
Mr. Amoke, you are for which party?
I appear personally.
You are which petitioner?
I am the 43rd petitioner, Your Lordship.
Once more, permit me to also place my senior, Mr. Maanzo, on the quorum for the 44th, 45th, 7th, 8th to 49th petitioners.
Yes. The respondents.
Please, you, my lord. My name is Gidu Mugai. I'm instructed by the Honorable the Attorney General to appear on her behalf, and I appear with my learned junior, Mr. Christopher Marwa. With your permission, I have taken the liberty of introducing everybody appearing. I have my learned friend, Mr. Gumbo, Mr. Nyamodi, and Mr. Ouma appearing for the National Assembly. I have my learned friends, Professor Tom Ojienda, Senior Counsel, and Mr. Mokele appearing for the Senate. I have my learned friend, Dr. Mufwani Nkolo, Senior Counsel, appearing alongside Moses Kipkogei, Ken Meli, Kenson Motadia, Boniface Maura and Steve Ogola for the Honorable Professor Kidiki, the second respondent. Sorry, I am corrected there. The Honorable Professor Kidiki, the second interested party. And I am advised that there is Mr. Bore for the first and eighth respondents, and that should cover the respondents and the interested party. Thank you. I am corrected yet again that I have omitted the name of Ms. Thanje, who appears for the Senate, and who is not here before. My apologies.
You said she's Miss?
Thanje, my lord.
My lords, my name is Michael Moshemi. I am here together with Paul Obula for the ninth respondent. Your Worship, I'm also requested to introduce Ms. Gadira, who holds brief for Dr. Kamogo for the 10th respondent.
Is that all for quorum?
That appears to complete the appearances. May I proceed?
Not really. Thank you very much. We've taken the quorum. There's some preliminary issues we want to address before we proceed. The first one is to apologize that we were not able to get the ceremonial hall to where we could have been much more relaxed than we are in this place, because the ceremonial hall is being used for other purposes. That was a promise that we made. We are not able to keep it. Therefore, we apologize for that. To ameliorate the issue, we have created an overflow courtroom, that is court number 325, where there's a screen, and therefore you can inform others who may want to be here that there's an overflow courtroom number 325. The second direction we want to make is that we had selected 3 days for the hearing of this petition. That is today, tomorrow, and the day after tomorrow. But for reasons beyond our ability, we are not able to proceed tomorrow or the day after tomorrow. This is so because one of us here, Justice Murima, is a member of the Judicial Service Commission, and they are carrying out interviews for the Supreme Court. That is an assignment which he cannot avoid. And therefore, we will adjourn after today. We wanted to let you have this information well in advance so that you are aware even as you argue the petition. For that reason, we have decided, and we hope that you will accept this decision because getting a date is very, very difficult, that the second hearing will take place on 7th of May, and the third hearing will take place on 8th of May, all starting at 10 a.m. The last direction concerns petition number 586 of 2024. Is Councillor Kinyanjui in the House? Mr. Kinyanjui?
Yes, my lord, I am online.
All right.
I was informed that it would be hybrid. I am here for the petitioner. I'm present.
Yes, we will mention your matter, this petition number 586 of 2024 at 4 p.m. today.
At 4 p.m. today?
Yes.
Thank you very much.
Thank you. I think we are now ready to go.
May I seek a small clarification in respect of today, up to what time in the morning section does the court intend to sit? In other words, when do we break for lunch? When do we come back? If we break for lunch at all, we are in your lordship's hands.
Yes. I think it would be prudent for us to break at 1 and come back at 2.
Thank you.
Yes. Senior Counsel Paul Mwete, we would like to know how many will be addressing us so that we allocate time.
For the 8 counsel appearing for the petitioner, the first petitioner. And my lords, your ladyship, bearing in mind that the first petitioner is the subject of the impeachment, the main pleader in these proceedings, we have divided the highlighting of the submissions amongst the 8 of us. Perhaps my learned friend, Senior Counsel Elisha Ngoya, and myself will take a little longer than the others. But the plea I'm making with what I'm saying is to plead with the court to bear in mind that this is the first opportunity. The petitioner, first petitioner, is having for stating his case. I plead that he be given adequate time. Thank you.
So what are you proposing?
I am proposing, in other words, my lords, that you kindly allocate me 1 hour, give or take, and Elisha Ngoya 2 hours, give or take, and the others 30 minutes, give or take. That will be adequate for us. In fact, this honorable court had indicated when we last appeared before the court that we would have today for the petitioner's case. And because there are many petitioners, I was just saying the person most affected is the first petitioner.
All right,
Yes, my lords and my lady, on our part, the third petitioner, we would request to be given 1 hour.
If it may please the court, Mamani for the 58th petitioner, we'll just take 20 minutes to highlight our submissions. Thank you.
Your Lordships, between myself and my brother Sakimpa, we'll equally need 1 hour.
Even as we make those submissions, bear in mind that a day has so many hours.
We endeavor to make it shorter.
All right. I think we'll proceed on the basis that we'll give you as much time as humanly possible within a day.
We are grateful, my lord. May I start now?
Yes.
My lords, your ladyship, the court will recollect that when we last appeared before this noble court on the 24th of February 2025, I stated to this honorable court on record on behalf of His Excellency Rigathi Gachagua that he was abandoning his prayer for reinstatement as Deputy President of the Republic of Kenya. To that end, His Excellency Rigathi Gachagua amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition, he abandoned the prayer for reinstatement. I wish, again, my lords, your ladyship, to reiterate that position on record. My lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August 2025. The core of those prayers can be summarized as follows. One, the quashing, if this court agrees with our submissions, the quashing of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law, plus damages. And finally, for the period of 2.5 years that His Excellency Rigathi Gachagua served as the second Deputy President of the Republic of Kenya, it is our submission that Article 151 of the Constitution is fully applicable, and I invite your lordships and your leadership to have a look at that Article 151 when you retire. Briefly, my lords, impeachment cannot and could not have been retrospective. That is the submission I'm making. My lords, your leadership, the petitioner, first petitioner, relies on the following documents. One, his further amended petition dated 13th of August 2025, the verifying affidavit thereto, and the annexures, which are in 9 volumes, dated 18th of October, 2024. Number 2, his bundle of authorities and case digest, dated 7th of October, 2025. And number 3, the first petitioner's written submissions, dated 7th October 2025, which submissions are the ones we are highlighting today before this honorable court. My lords, paragraph 1 to 19 my colleague is drawing my attention that we are also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April, 2026. Thank you. My lords, your leaderships, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this honorable court, when it retires, to read this background in full. But permit me to briefly draw the court's attention to only 3 matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. And I would draw this honorable court's attention to paragraph 5, which you will find at page 7 of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful. The exercise did not provide the public, for example, with the Deputy President's side of the story. The public was only presented with the allegations made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. My Lord, it is our submission that that is a mockery of effective public participation under the Constitution. And you'll find what I'm saying in the exhibits, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go, that the entire process was conducted by the National Assembly through to the Senate, breakneck speed, lightning speed. And the question that arises is why this speed? And our submission is that the only inference that can be drawn, and we drew, and we invite this Honorable Court to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. My Lord, if you look at paragraph 8, 9, and 10 and 11, and they appear from page 8 of our written submissions. Paragraph 8, my Lord, you see the respondent, the third respondent, convened a session of the Senate on 8th October 2024, which then passed a resolution that the plenary would hear and consider. And I pause here to emphasize the word plenary, my Lord, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fairness, fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution, the standing orders, it was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President, the first petitioner, the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on, refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced as scheduled on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was fully discredited in cross-examination, and this Honorable Court will be taken through all that by my learned friends here. In number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President, not the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the National Assembly, despite, or on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional colleague. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach the Deputy President on 5 out of the 11 counts. And you'll find all that in RG 11, Volume 9, pages 1689 to 1725, response by Rigathi Gachagua. And also RG 12, Volume 9, pages 1752 to 1758, communication from the chair. My Lord, the third matter I wish to very quickly draw the court's attention to in this introduction background is the absolute failure for both the National Assembly and the Senate to address their minds to the threshold that the Constitution lays down for impeachment of a person elected into office by a plurality of votes. And here, my Lord, permit me to draw the court's attention to the fundamental distinction between presidential systems of government and parliamentary systems of government. In a parliamentary system of government, members of parliament are entitled and have the right to kick the Prime Minister out of office simply by passing a no confidence resolution. No one can question the members of parliament why they had lost confidence in the Prime Minister. There are many examples of parliamentary system. England is a parliamentary system. India is a parliamentary system. And in fact, although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by votes, a majority of votes by members of parliament. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our Constitution. that members of the National Assembly can vote and christen their resolution that there are breaches of the Constitution, and you'll be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with a person being impeached. One of last resort. Let me pause here to emphasize that in the National Cohesion Act, currently headed by my friend Reverend Kovia, one of the charges leveled against the first petitioner, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is a last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. And Lord, what I am highlighting here is what the court says in the Sonko moving Gideon Keoko and another versus Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy president meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I said, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. My Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. My Lord, if you go to page 11 of our written submissions, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. My Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the Deputy President to be addressed by each one of us. My Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed by different council. My Lord, the issues I want to address in those issues listed in paragraph 17 are 1, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the Deputy President a fair hearing. And it is our submission, a very critical submission, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2010 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations, whether that was unconstitutional. My Lords, Your Leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you'll find that in Exhibit RG1, Volume 1, page 2 to 41, the notice of motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional organ. My Lords, your leadership, my learned friend Ndego Wanjiru here, and myself had the privilege of arguing the Wabora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. My Lord, the drafters of the Constitution could have said violation of the Constitution or other written law. They didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wabora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against the governor, in this case, deputy governor, and may I say, not just the deputy governor, the law that this Honorable Court will be laying down or reiterating will apply to the impeachment of the president himself. It's very weighty issues that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president or the president and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code. 5 years before the Deputy President's election to office, ground 8 of the impeachment motion alleged
the opinions
the
may be
Deputy
controversial.
President had violated
The opinions may appear
that nullified law warranting his removal from office. By impeaching the Deputy President on the basis of a section that had been nullified by this court. What Sigin knew was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. My Lord, you will find that authority, paragraph 62, alike is, pages 62 to 63.
Express yourself as you will. If you read a document that talked about shareholders, that is what you say when you go to the public. Why would you be vilified and impeached from ever holding public office for reading a document that founded a government? On what basis? He then says, even if they invite disagreements and counter demonstrations, this is the first by people on the basis of a document. And so the DP's public references as regards these shareholders cannot be tantamount to hate speech. They cannot. This is public speaking, as I've just stated. And I should state here, the case of Ferdinand Ndung'u Waitito and the four others, among the four others are the current leader of majority in the National Assembly. So he knows this. When they were considering these grounds, he was aware of this decision because he was one of the petitioners. And they were told, no, you can't stop people from talking. Now, but then, they then went to the Supreme Court, the Court of Appeal, sorry. They tried to overturn this decision, and the Court of Appeal rejected that attempt. So this decision, I'm reading Ferdinand Waitito, has been upheld as well by the Court of Appeal. There are many instances where one would be said to have caused the hate speech or incited people or have said things that weren't popular. The first petitioner is accused of having spoken against the National Intelligence Service. When you retire to review the material before you, this is the Senate Hansard, and this is ground number 9, which you'll find at page 64. There is an interesting exchange where my good friend Ekomas Mutuse is being interviewed, is being cross-examined on the question of the NIS. And he's directed to a case where the current president, who, while deputy president, also very harshly criticized the NIS. So criticizing the NIS has not started now. In fact, the current first petitioner, who was the deputy president, should be accused of being a good student of his boss, the former deputy president, who's currently the president, because he too also criticized the NIS. So, and the NIS, as with any other state organ, can and should be criticized. No one is beyond criticism so long as it is well-founded, as turned out in this case. It is made politely. It is stated in good English, relatively good English. Our client spoke some fairly good English. He's a literature graduate. He's said nice things. He said them nicely. Now, they offended the heart. But you know, no one is beyond criticism. One of the other things, I think, and we've stated this in our petition and submission, again, on the question of bias, the National Assembly Deputy Speaker, the 8th respondent, is on record as saying her instructions to execute the impeachment came from a building in Kilimani called State House. And one of the things the court is invited to look at is whether the person exercising this decision acted on the direction of a person or a body not authorized or empowered to give such directions. Now, one of the other issues that this court is asked to look into is whether the administrative action is rationally connected to the information before the administration. Again, as I have said, it cannot have been rationally connected to this decision when among the grounds was a law that did not exist, was issues pending before the succession court, was the exercise of freedom of expression under Article 33. I will not repeat the question about the issue, but it's one of the other issues, again, you'll be able to look at. The question of these shareholder agreements, I need not say more about that. But is the decision unreasonable? The ungodly rush to execute a premeditated decision is unreasonable. A one-day notice to the public to conduct public participation regarding a matter that even this court has said is of great public importance is unreasonable. Conducting public participation in which the public only has access to the impeachment motion, a summary of it, by the way, The evidence was not given to the public. They were just told he has violated article this, section this, and section that. Most lawyers could not tell you, with most, leave alone the public, other than my good friend Mr. Umtata. No public member can read these sections out of their head. And yet this is what they were given on this document and told, should we impeach this man or not? Passing a resolution based on public participation, as I said, that had 0% of voters who cast the votes in 2022, is unreasonable. One of the other criteria is whether the administrative action or decision is not proportionate to the interests or rights affected, and whether the impugned action or decision violated the legitimate expectations of not only the Deputy President, but the nation at large. Now, the case I cited earlier, which is the 2025 IEBC versus AG case, states the following words. Kenya's history is one of executive overreach and institutional compromise. This is what the Supreme Court said last year. And for the avoidance of doubt, Section 12 of the Fair Administrative Action Act states that the act is in addition to and not in derogation of the general principles of common law and of natural justice. Now, as I said, the National Assembly and the Senate violated all known canons of fair hearing and constitutional procedure. Amongst the most harmful things they did was to destroy almost the principle known as the principle of legitimacy. The principle of legitimacy has 3 pillars. Pillar number 1, people must have voices and their voices must count. That's the first pillar of the principle of legitimacy. The second one is that public affairs and the law must be conducted with fairness and justice. That too was violated. And thirdly, that laws and rules must be consistent and applied evenly and predictably. I repeat, the current Deputy President is the witness of these shareholder agreements that led to the impeachment of the Deputy President seated here. The President, the Speaker of the National Assembly, the Speaker of the Senate, all are members of parties that signed and are beneficiaries of this agreement. How can we say the law is being applied equally, fairly, and evenly, even in the limited space of the political players, when one group is treated one way and one individual is treated another way? I want to rest this area of my submissions, and perhaps maybe you should allow me to just read for you, as I found my notes on the provisions of the Elections Act and the IEBC Act that deal with the question of nominating a Deputy President. These are Articles 82(1)(b), Article 88(4), the definition of the word nomination at Section 2 of the Elections Act, Section 22 of the Elections Act, and Section 4D of the IEBC Act. I want to close with the following paragraph taken from the decision of the IEBC versus Attorney General 2025 case. This was a case concerning the delimitation of boundaries, and the Supreme Court of Kenya said as follows. And this is the penultimate paragraph of their judgment. However, before we conclude, we must address a matter that has troubled us. And it is my very, very tremendously humble and respectful request to this court to also be equally troubled by the things that the National Assembly and the Senate did in this matter. The history of Kenya's electoral process, from the findings of the Kriegler Commission after the 2007-2008 post-election crisis, to the litigation around elections culminating in the 2022 presidential election, reveals a consistent theme, one of a deep-seated trust deficit. I beseech this court, do not countenance any further trust deficit based on the things the National Assembly and the Senate did. Trust deficit between Kenyans, the IEBC and the electoral process. This deficit did not occur by accident. It occurred because of actions like the ones by the National Assembly and the Senate. Rather, it is the product of decades of politicization of the electoral process, relentless attacks on the Commission's independence, and a failure to implement electoral reforms in a good time and in good faith. Leaders exercising delegated authority, such as the National Assembly and the Senate, on behalf of the people under the Constitution, rather than fueling this mistrust for short-term political gain. It appeared last year, 2024, when the impeachment was going on. It seemed that there was a deadline by 20th October. And when I slept, I woke up with a eureka moment. The idea was to have a new deputy president at the holiday. You know, it gripped me. I hadn't seen it before, you know. And so undermining the very institutions they are duty-bound to protect should channel their power and influence toward addressing structural weaknesses, enhancing accountability, and reinforcing public confidence in the impartiality and competence of the IEBC. In this case, I say of decisions by the two bodies before you. Ultimately, the legitimacy, which is why I spent some time talking about the doctrine of legitimacy, and this is what they say. Ultimately, the legitimacy of Kenya's democratic order depends not only on credible institutions, but equally on the fidelity of political actors to the spirit of the Constitution and the sovereignty of the people, which was in question during this impeachment. Unless your ladyship and my lords have any questions for me, I want to thank you for the privilege of your time and attention. I'll rest at that point. I hand over to my senior, Mr. Swanya.
Thank you. I would like to make this comment that repeated issues are coming up in your submissions, and I want us to believe that we have heard most of those issues. If you find that you are bound to repeat what has been said, we want to assure you that it is not necessary.
Thank you. My name is Swanya. I'll address the court on nopses. But before I do so, let me cite the Supreme Court, a case on PAT, which says public participation is a constitutional requirement under Article 10 and 118 of the 2010 Constitution. The Supreme Court in a PAT case held that public participation and consultation is a living principle that went into the constitutional tenet of the sovereign of the people. Under Article 10, Sub-Article 1 and 2, as a constitutional principle, public participation binds and it is applied to all aspects of governance. Your Honors, and lady, I want just to get down to some specifics on public participation. It is designed to ensure accountability, requiring public engagement, rather than just parliamentary approval. In the context of impeachment, it is a remedy of the last resort. This, I think, was mentioned by Senior Counsel Paul Mwite. Therefore, the public participation exercise must meet the following standards, and this is what I wanted to get down to the specifics. One, must be purposeful and meaningful. Must be real and not illusory formality. It is not cosmetically done for Public Relations Act. Should not be undertaken as a matter of just to fulfill a constitutional requirement. The public participation exercise outcome must have quantitative and qualitative components. It is accompanied by reasonable notices and reasonable opportunity. Further, Your Honor, the court tried to highlight what is the components of meaningful and purposeful public participation. It must have clarity of the subject matter of the public, for the public to understand. The structure and process, that's the media of communication, of the participation, participation that are clear and simple to understand and follow. This particularly is the instruments that are used to collect data or to be given to the participants on public participation. They got to be simple, clear, and easy to follow. There must be opportunity of balance influences from the public in general and commitment to the process. It must be inclusive of effective representation, integrity and transparency of the process, and capacity to engage on the public, including that the public had to be first be sensitized on the subject matter. These are the details that our guidelines the Supreme Court gave on the PAT case. So now let me just get straight to the notices. Before I get to the details of it, let me define what a notice is and a reasonable notice. A notice is a formal information to parties attached or necessary to a judicial process, informing them about the issues they need to know and given an opportunity to respond to them. The courts always will rely on the parties to properly serve notices to the affected parties. A proper notice is regarded to be proper and adequate when it has the following elements. Number one, it must be in writing and indicate the date issued.
And although
it must be clear and precise or state the clear
where there are serious reasons for believing that the Deputy President has committed a crime, in Ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Ladyship, the Senate voted on that impeachment charge on the basis of a repealed section. And you'll find that in Exhibit RG 3, Volume 6, pages 745 to 747. And my Lord, although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in Ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security agent. Now, my Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director. My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS, under the Constitution, 239, sub-article 5, is supposed to be under civilian oversight authority. And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is cap 206 of the laws of Kenya. You will find in part 3, civilian authorities, the heading, effective surveillance authority are repealed sections of the Penal Code, the leadership and integrity without ever charging him.
This matter of the National Assembly to the present. This question has disturbed me as a role player in the justice, law and order sector. That the Senate of Kenya, even after the Speaker erroneously, and I use the word erroneously, advisedly, because my learned colleague, Mr. Dudley, will take you through the timelines for impeachment in Article 145, as read that 150 of the Constitution. But even after the Speaker erroneously said, we have a timeline of Saturday. They had no such timeline, but the Speaker said so. The senators voted to deny the Deputy President the benefit of those 2 or 3 more days without giving any reason. I would want to read in your judgments, my Lord and my Lady, through what logic this court will allow that decision to stand, if no other decision, that particular one. That for no reason, we are not saying the heavens will come down falling. We are not saying the country will be subject to any external attack. We are not saying there is any constitutional imperative that compels us to do it tonight. No reason. They simply said, we will not give him the benefit of those 2 days that the Speaker has said we still have. Let's go on record. The Speaker too was wrong. But there may have been some veneer of good faith. If they had said it's okay, because we have 2 days, let us give him the 2 days for whatever it is worth. They said, even that, we are not going to give it to him. On the threshold questions, the matters that I'm specifically tasked to bring to your Lordship's, Ladyship's attention are the following. Number 1, Article 150, Clause 1 of the Constitution sets out the constitutional textual threshold for removal of a Deputy President from office by impeachment. And it says is on the grounds of gross violation of a provision of the Constitution or any other laws. Secondly, it says is on the ground of serious reasons to believe that the Deputy President has committed a crime under national or international law. Serious reasons. I'll be making out a simple case that the National Assembly really disappointed the country. To approve a motion that there are serious reasons to believe that the Deputy President has violated a provision of the law, Section 132 of the Penal Code, which has been declared unconstitutional, null, and void, is a locus classicus of lack of seriousness in the reasons. And thirdly, the standard of gross misconduct. Let's face it, my lords, my lady. The drafters of this constitution could as well characterize these wrongs as violation of the constitution, because that's also a wrong, or reason to believe that the DP has committed a crime, or misconduct. Those are wrongs. But they were particular to add these descriptive words, gross, to the violation, gross to the misconduct, and serious to the reasons. The conclusion I draw from this is that they set a very high threshold for removal of a deputy president from office. Our courts have followed cue. I will start with the Supreme Court, sample 2 decisions there. Go to the Court of Appeal, sample 1 decision there, then go to the High Court and sample 1 decision there. From the Supreme Court, the decision of Sonko versus the County Assembly of Nairobi City and 11 others.
Mr. Ongaya, you have submissions on this, eh?
Yes, yes, we do.
This one, eh? You have submissions on this?
Yes, we do.
We filed, eh?
Correct, correct.
You can also be referring us to the pages.
Okay, okay. I'm highlighting, my lord, so I was avoiding reading them. So I'm drawing simply because if I have to take you through the pages, then it means I have to actually take you through the submissions themselves. I'm just highlighting salient aspects of those submissions so that we save on time.
All right.
Thank you. So that in Sonko versus the County Assembly of Nairobi City, I beseech this court to look at paragraph 161 of that judgment. The Supreme Court observed that the grounds for impeachment and removal from the office must be substantiated. The grounds for impeachment and removal from office must be substantiated. It means, my lords and my lady, the motion mover and his supporting cast of witnesses must show us where is the supporting evidence for each of those grounds. They must show where the supporting evidence is. Because substantiation simply means adduction of adequate evidence to lend credence to the ground. The Supreme Court then sets the standard as what has now been called the intermediate standard. Not so low as to be on a balance of probabilities, and not so high as to be beyond reasonable doubt. You will find these descriptive words of grounds for removal from office in removal of other office bearers from office under our constitution, like judges of superior courts. They'll be removed on similar grounds. And you'll see the Supreme Court has dealt with that in the case of Muya versus the tribunal appointed to investigate the conduct of Justice Martin Mati Muya, Judge of the High Court. In that matter, the Supreme Court now attempts to give us the meaning of the word gross. And you'll find that at paragraph 181 of that judgment of the Supreme Court. And it says, and I quote, clearly, all the words used to describe gross express some extreme negative conduct. Not just negative conduct. It says extreme negative conduct. Then it proceeds to say a degree of misconduct of such a serious, outrageous, and flagrant nature that would warrant removal of a judge from office. That is how serious it ought to be. Those are the words of the Supreme Court. So, the Court of Appeal, I have already observed, set that standard in the Martin Nyaga Wambora and 3 others. I'll just refer you to paragraphs 42 through 45 of that judgment. But there is something else that I want us to draw from the Martin Nyaga Wambora case. How to frame charges for an impeachment motion. Because the Court of Appeal also dealt with that question. And when you look at paragraph 44 of the Martin Nyaga Wambora decision, the 2014 Court of Appeal decision, that's the one I have in mind. If you look at paragraph 44, you will see that the Court of Appeal draws similarities in drawing charges for an impeachment motion to drawing criminal trial charges for court. In fact, the court uses an example of how to draw a charge of robbery with violence in trying to explain how specific a charge for impeachment should be. I say this because in drawing criminal trial charges, there is a wrong in framing charges called multiplicity of charges, and I'll show you how that wrong applied in the trial of His Excellency Rigathi Gachagua. Then finally, for the High Court jurisprudence, I will refer you to the High Court decision in Honorable Mike Sonko Mbuvi, Gideon, and Okia Omtata versus the Clerk, Nairobi City County Assembly. These were 2 consolidated petitions. And I will draw your attention to paragraphs 257 through 259 of that judgment of the High Court. For ease of reference, I will refer you to the various aspects of the impeachment motion that is in volume number 1 of the petitioner's document from pages 1 to 209. Look at that volume. And I'll refer you to the Hansard proceedings of the Senate. You'll find the Hansard proceedings of the Senate in the documents filed by Mukele Moni advocates in the CTS that are labeled Parts 5 and Part 6. Part 5 and Part 6. In Part 5, you'll find the Hansard of 16th October 2024. Then in Part 6, you will find a continuation of the Hansard of 16th October 2024 and the Hansard of 17th October 2024. That Hansard is also referred to in the affidavit of my very good friend Jeremiah Nyegenye as Annexure JN10 at paragraph 31 of that affidavit, which was sworn on 21st October 2024. So, returning to the question under scrutiny from my end, I would invite you to look at page 59 of the Hansard of 16th October 2024. This is now the page of the Hansard itself, not the page of the bundle, because my learned colleague, Mr. Mukele, did not paginate the full bundle. So you'll look at the page of the Hansard itself. Something very interesting happened. I want to paint the picture so that I abridge on time. Before the trial of His Excellency Rigathi Gachagua at the Senate issued a trial schedule, a schedule of the proceedings. The National Assembly had given the Senate a list of 5 witnesses. His Excellency, the Deputy President, had submitted his affidavit alone as his own witness. So the DP side had 1 witness, being the DP only. The National Assembly presented 5 witnesses. When the schedule came, the schedule gave the DP's team 2 hours to cross-examine the 5 witnesses of the National Assembly and 3 hours to lead the evidence in chief of the Deputy President. The Deputy President's team took the view that it did not need 3 hours to take their witness in exam in chief. This is their own case. They suggested to the Speaker that we need these 3 hours for our exam in chief and perhaps the 3 hours for our cross-examination of the National Assembly witnesses and perhaps the 2 hours for our exam in chief. So we are not taking any more time of the Senate. We're just reordering our own time, the one you have given us. At page 59 of the Hansard of 16th October 2024, the Speaker dismissed that literally by wave of the hand. I mentioned three significant trials that have shown me that when these kind of things happen, it means there is malicious compliance. We are simply going through the motions. No one is asking for the Senate any more time. We're just saying of the time you have allocated us, we have a lot more duty in cross-examination. Give us more time towards that. We have lesser duty in exam in chief. From our own time, give us less time on that. It is judicially noticeable that the Speaker of the Senate is a lawyer of many years standing. It cannot be that he didn't understand the injustice inherent in the disproportionality in that time allocation. It cannot be he didn't understand. He understood it by virtue of the trust bestowed upon him as a trained lawyer. He breached that trust. Allow me to then very briefly take you through the various grounds of impeachment as set out in the motion and the evidence, what the evidence revealed in respect of each of those grounds. I will start with the ground number 4 of the impeachment motion. The particulars of that ground will be found at paragraph 34 of the motion itself. The particulars of ground number 4 will be found at paragraph 34 of the impeachment motion. This is one of the grounds that the Senate approved and which contributed to the loss of office of His Excellency Rigathi Gachagua. The particulars state that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. it is a requirement in impeachment proceedings that the impeaching House cannot introduce any new grounds at the Senate stage. They are held to account on the grounds as approved by the National Assembly. The ground was that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. So a number of things are important, my lords, my lady. One, what does Article 160, Clause 5 of the Constitution provide? It provides that a member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. It's not liable in suit. You can't take them to court. If you look at ground number 4 and particulars at paragraph 34, it is alleging that the threat to take a judge to the Judicial Service Commission is a violation of Article 160, Clause 5. I wonder, their lawyers are here, they will tell us. In fact, some senators are actually here. They will tell us. How does Senate read Article 160, Clause 5 as against Article 168, Clause 2? Because Article 168, Clause 2 constitutionally gives any person the right to initiate a petition before the Judicial Service Commission for the removal of a judge. So if you state that you are going to pursue an Article 168, Clause 2 process, how can that be a violation of Article 160, Clause 5? I was taught many years ago, I hope it's still the learning today, the Constitution is not self-annihilating. We cannot read Article 160, Clause 5 to destroy Article 168, Clause 2. So that the National Assembly brought a case to the Senate that a claim by the Deputy President that he is going to file a petition against Justice Esther Maina is a violation of Article 160, Clause 5. The Senate approved that ground for removal of the Deputy President. Now, let's not lose focus of this, my lords. The express text of the ground and the particulars at paragraph 34 of the motion is that the Deputy President had falsely threatened to file a petition against Justice Maina. Now, the Supreme Court has told us the ground must be substantiated. So I will now take you how the motion mover substantiated the ground. If you look at page 60 of the Hansard of 16th October 2024, so on the attached to the affidavit of Jeremiah Nyegenye as Annex J N10, the following conversation takes place. The motion mover is being cross-examined by yours truly. The Hansard of the Senate presented the complaint to the Judicial Service Commission as at that date. The motion mover says, I have since learned that he did present the petition. The motion mover is conceding that his claim in the motion that the Deputy President falsely threatened to file the petition cannot pass muster. Yours truly, my lords, then suggests to him that to the extent that you say that he has not presented the allegation to the JSC as at 26th September 2024, that allegation is not true. Is it? The motion mover says, we are in agreement, counsel. the motion mover concedes that the ground on which his motion is founded, ground 4, cannot be substantiated. With this Hansard before them, members of the Senate voted to approve this ground. Can it be said that in view of this concession by the motion mover, that ground had been substantiated, that it passed the threshold? The third aspect I want my lords to reflect on when you retire, you can answer this question either way. Some of us enjoy reading these judgments either way. But I want direct answers to these questions. A judge has had a case and delivered a judgment and become functus officio. Can a verbal criticism of the manner in which that judge conducted herself in that case constitute a violation of the decisional independence of the judge? That's what the ground said. It said gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Can a verbal criticism of a judge, because of a decision she has already rendered and become functus officio, amount to a threat to the decisional independence of that judge? Which decision? She has already rendered the decision. I submit to you, my lords, that it is actually good democratic practice to subject judicial decisions to heightened scrutiny. It is good practice. It grows judicial accountability. And therefore, what the Senate did by approving this ground was a clawback on an important democratic practice of enhancing judicial accountability. The two grounds that I want to deal with simultaneously are grounds 5 and 6, because they suffer the same fate of inadequacy. Grounds 5 and 6. Ground 5, and both of them were approved. So I've already dealt with one that was approved. I'm dealing with two others. Then I'll deal with two others to finish the 5 that were approved. Ground 5 accused the Deputy President of gross violation of Articles 3.1 and 148.5a of the Constitution and fidelity to the oath of office and allegiance. Then ground 6 provided that the Deputy President, that there were serious reasons to believe that the Deputy President had committed a crime under sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Those were the two grounds. So, a ground must be supported by particulars. That's what the Supreme Court has said. Then the particulars must be substantiated. Now, when you look at the motion, ground 5 had no particulars of its own. Ground 6 had no particulars of its own. Instead, what the drafter of this motion, in his drafting wisdom, did was to say the grounds in support of ground 5, the particulars in support of ground 5 are the particulars in grounds 1, 2, 3, and 4. That's what he said. Similarly, in respect of ground 6, the drafter didn't supply particulars. Instead, he said the particulars in support of ground 6 are the grounds set out in, the particulars set out in grounds 1, 2, 3, and 4. My lords, as experienced jurists, you know better than I do that particulars are the specific acts or omissions constituting the wrongdoing. The specific acts or omissions constituting the wrongdoing. The National Assembly went to the Senate and said, we are charging the Deputy President in ground 5 and ground 6 because of the acts and omissions we have referred to in grounds 1, 2, 3, and 4. Is that a permissible way of framing a charge of impeachment? I began by setting out that it has been established that the grounds, the charges in impeachment are framed in the same manner as charges in a criminal case. This court, the High Court rather, has held in 3 different cases. The case of BMK versus Republic, 2020 EKLR. The case of LKO versus Republic, 2022 EKLR. And the case of Etiang versus Republic, 2022 EKLR. I'll just refer to one because they make the same principle. Justice Ongudi said, and I quote, "The problem I find in the charge sheet is one of multiplicity of charges." Then she defines multiplicity. Multiplicity in a charge sheet arises from charging of a single criminal act as multiple separate counts. This may result in violation of the right of an accused person under Article 50, Clause 2, Paragraph O of the Constitution. That multiplicity of charges is a violation or a threat to Article 50, Clause 2, Paragraph O. And it defines multiplicity to mean charging a single act as multiple separate counts. So therefore, when the National Assembly tells us that the acts in ground 1, 2, 3, 4 are the same acts that constitute the ground 5 and ground 6, these 2 grounds were bad for multiplicity. They were a violation of Article 50 of the Constitution. They cannot found a threshold for impeachment. Both of the 2 grounds were approved by the Senate as constituting the basis for removal of the Deputy President from office. But there's something very bad about it. The Senate voted to approve grounds 5 and 6 on the particulars set out in 1, 2, 3, and 4, and ground 5 on the particulars set out in the grounds 1, 2, 3, and 4, but acquitted the Deputy President of grounds 2 and 3. And remember, they gave no reasons for convicting. And that's how obscene this trial in plenary is, as my learned colleague, Mr. Chell Dudley, will take you through in a short while. Then finally, ground 1. Ground 1 accused the Deputy President of gross violation of Articles 10(2)(a), B, and C, 73(1)(a) and 2B, 75(1) and C, so 75(1)(c) and 129(2) of the Constitution, and Articles 47(1) as read together with Articles 131(2)(c) and D of the Constitution. In summary, my lords, these were the grounds that accused the deputy president of talking about shares in government and shareholding in government. Let me just paraphrase it like that. That's in summary what this is about. My learned colleague, Mr. Tom Masharia, took the motion mover through cross-examination on this ground. You will find that at pages 88 to 94 of the Hansard of 16th October 2024. So a number of things emerged. I just summarize them. Number one, the motion mover confirmed that the government of the day in Kenya is formed by a coalition of parties named the Kenya Kwanza Coalition. Motion mover confirmed that as a fact. Number two, he confirmed that the Kenya Kwanza Coalition was formed of pre-election coalition agreements involving various parties. Number three, among the parties were UDA, ANC, Ford Kenya, and PAA or PA, as is sometimes called. And my lord, this must come out very succinctly from me. It bears that PA is the party whose party leader was the Speaker of the Senate presiding over these proceedings. When you finally take time to read pages 88 to 94, the motion mover confirmed that each of these coalition agreements made references to sharing of government. And they expressly spoke about sharing government positions and sharing resources. You will see the coalition agreement between Ford Kenya and ANC talking about certain roads in Western Kenya, nowhere else. You will see the coalition agreement with the PA talking about development of marine resources in coastal Kenya. You will see positions, the leader of Ford Kenya being promised the position of the Speaker of the National Assembly and certain cabinet portfolios and principal secretary portfolios. The leader of the party called PA being promised a position of the Speaker of the Senate. The question, therefore, is that when parties enter coalition agreements and pre-election manifestos, it is the people who determine whether they want to be associated with that kind of manifesto or that kind of pre-election arrangement at an election. For some reason, the people of Kenya chose this agreement with shareholding arrangements in 2022. If the people of Kenya are unhappy, they have another opportunity in 2027 to deal with it. And that is exactly what the High Court set out in the Sonko decision that I have just referred to. If you look at the High Court Sonko decision at paragraph 258, the High Court says, an impeachment is an important remedy, but one of last resort. It is one to be used where there is an injury to the people. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed came to office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. If the people of Kenya had gone to the 2022 elections on the strength of these pre-election arrangements that talked about shareholding, it follows that they had a chance to revisit that question at the next election cycle. That's what the High Court is telling us. But, my lords, the more interesting one for me is at page 95 of the Hansard of 16th October 2024. You'll find the following very interesting conversation between Counsel Tom Macharia and the motion mover, Ecomas Mwenge Mutuse. I'll briefly take through the conversation, my lord, but you will take note of the pages and revisit it when you retire to do duty of writing judgment. Tom Macharia begins by playing a video to the motion mover and posed the question, who is speaking in that video? The motion mover, Mwenge Mutuse, responds, the President of the Republic of Kenya, Honorable William Ruto. Tom Macharia then poses the question, which words did he use? What did he say to the people of Murang'a? Mwenge Mutuse says he has appointed many of the locals into his government. Tom Macharia prods further, did he say, nyinyi watu wa Murang'a ni shareholders wakubwa wa hii serikali? Mwenge Mutuse says, yes, he did. The people of Kenya have no difficulty waiting to assess their president at the next election cycle in 2027 following this conversation. The question we want you to deal with is this. Why is the president's reference to the people of Murang'a as shareholders in his government acceptable political rhetoric? And a similar reference to the people of Nandi and Kericho, because those are the areas mentioned in the motion, by his deputy, an impeachable offense. It's worth noting that when you read the conversations I've told you at pages 88 to 94, you'll find that the person who witnessed the pre-election pacts in Kenya Kwanza was Professor Kithure Kindiki, and despite witnessing agreements with the shareholding model in it, the National Assembly had no difficulty approving it now to become the deputy president. It is that uneven-handedness that we want this court to ask itself this question. Did the nation establish who is the wrongdoer to be punished, then found the deputy president? Or did it find the deputy president, then asked, what wrong can we put on him to punish him? Which is what appears to me to have transpired in this set of circumstances. I have taken you through the 5 grounds that were approved by the Senate to demonstrate to you that they were bad for multiplicity. That's grounds 5 and 6. They fell short of the threshold as set out in Article 150 of the Constitution, as expanded upon through judicial interpretation. And therefore, generally, they could not found a motion for removal of the deputy president from office. While principally, therefore, beseeching this court to allow this petition, allow me now to invite my learned colleague, Mr. Chell Dudley, to take you through the reading of the constitutional prescription on the impeachment procedure and how the interpretation of those provisions by the Speaker of the Senate fell way off the mark. Mr. Dudley, you're welcome. Thank you, my lord.
Thank you.
Thank you, my lord, for the opportunity to address you on this important question. When we last left the court, I had thought that we were done with jurisdiction. But the National Assembly spends the first 32 pages of their submissions saying that you either lack jurisdiction, or if you have it, then you're limited to looking at the process. And you should not hear the substantive violations that my two colleagues have told you about. They cite, quite helpfully to us, a Filipino case, Francisco versus House of Representatives, where the Filipino Parliament had similarly argued that the Filipino judiciary had no jurisdiction to review impeachment proceedings. The court concluded that that process has procedural safeguards, and therefore it answers to a legal process. My lord, that stance, the stance that the proceedings you're dealing with are both political and legal, is found in the report of the Technical Working Group D on the executive. My senior counsel, team leader, Paul Mwite, was a delegate number 114. The current speaker was delegate number 209 at the CKRC conference. And you'll hear Professor Githu Muigai, when he rises, tell you that these provisions on impeachment were hotly contested. They were the most contentious provisions. And so, my lord, detail was paid to these provisions. The law is that Parliament does not waste words. Every word in a legislation must be given a meaning. My lord, let me begin with what's common ground. On 9th October 2024, JN4, the affidavit of Jeremiah Nyegenye at paragraph 22, the morning sitting, in the Hansard, the Speaker of the Senate misleads the Senate, saying that we have two options to deal with this motion, alike the procedure for governors and deputy governors. He says we have a motion is the first for impeachment of deputy president, but we have two options that we have when it comes to the impeachment of deputy governors and governors. My lord, that is a heresy. And because of that, just common ground again, the Senate does not form the committee. The special committee under Article 145(3) is not formed. Why? The Speaker misleads the House that they have two options. They can either investigate the charges by committee, Article 145(3)(a), or they can investigate by plenary, like they do for governors. My lord, I request that my lords be given our rejoinder submissions, table 1, because I intend to spend a moment or two there. My lord, the Senate picks the 10-day timeline applicable to the special committee. Remember, they've dropped the committee. They've said, no, we have two options. We are investigating it in plenary. But they retain the 10-day timeline applicable to that special committee. And so, when the deputy president falls ill, my colleagues have addressed this, the Speaker holds on to the 10-day deadline applicable to the special committee for a plenary hearing. And the members of the Senate vote to deny the deputy president even the benefit of that 10 days, the balance of it. They say we must conclude our business today. In doing that, the Senate grossly violated the Constitution. My lord, let me bring your attention to table 1. In table 1, we've tabulated the differences between Article 145.3, Senate Standing Order 78 and 80, and Rule 2, Rules of Procedure for removal of the Deputy President by impeachment and governors. My Lord, Article 145.3 does not give two options. It gives one option, and it says that within 7 days after receiving notice of the National Assembly resolution, the Senate Speaker shall convene a meeting of the Senate to hear charges against the President, and the Senate, by resolution, may appoint a special committee comprising 11 of its members to investigate the matter. The special committee has a constitutional function. It investigates the charges for seriousness. Then it reports to the Senate. My Lord, there's a may which seems problematic here, but we'll tell you where that may originated. But as it is, it makes grammatical sense. The Senate must convene within 7 days, and if the Senate convenes in 7 days and the motion is approved, there's something worthy of investigation here, the Senate may appoint the committee. It must not appoint the committee always. Why? Because sometimes you'll find that it's flimsy. The charge is that the Deputy President, the President, wore a yellow shirt. He should have worn green. Or he wore a blue shirt when he should have worn a red one. Flimsy charges. My Lord, the test on threshold has already been laid to you. So literally, grammatically, Article 145.3a has an and. If you go to 143.5b and you begin with the Senate, by resolution, may appoint a special committee comprising 11 of its members to investigate the matter, and you leave the A, what have you done to the and? And is disjunctive. It means you must bring both elements of the law together. Parliament does not waste words. Every word used by Parliament in a law has meaning, and the court must give each word in the law meaning, especially if that law is a constitution. My Lord, staying with Table 1, Standing Order 78, which is a provision applicable to the President, reflects faithfully the wording in Article 145.3, word for word. Then, this is where the original sin happens. Standing Order 80, and that is on page 2 of our Table 1. I really hope that my lords have it so that we take this argument, because it's a technical one and it's on the details. But when you come to Standing Order 80, which is the procedure applicable to governors and deputy governors, it allows the Senate to investigate in plenary. Standing Order 81 says, within 7 days after receiving the resolution, the Speaker of the Senate shall convene a meeting of the Senate to hear charges against the governor. And the Senate may, 1, by resolution, appoint a special committee comprising 11 of its members to investigate the matter, or investigate the matter in plenary. The Speaker imports this or in Standing Order 80, brings it to Standing Order 78, replaces the and there. The Senate shall convene and may by resolution appoint a committee. He replaces that and, he deletes it. He uses or. So he tells the senators, you have two options. You can go investigate this by special committee, or you can investigate it by plenary, like we do for governors. My Lord, if you look at the constitutional article for impeachment of governors, you will not find the kind of detail that you have in Article 145. Why? My learned friend, my senior, Professor Githu, will tell you that this Article 145 was intensely debated. It was one of the most contentious provisions in the history of the making of the Constitution. So it comes complete with detail. But the Speaker here replaces the word or in Standing Order 80 and takes it to Standing Order 78 to Article 145.3. He deletes and implants or. What misled the Speaker could be is Rule 2. My Lord, that's the last item, number 4, on page 2 of our Table 1. Rule 2, Rules of Procedure, also makes the same mistake. It replaces the legislative word and in Article 145 with the or, disjunctive. My Lord, Rule 2 says the Senate may in plenary investigate the matter and determine whether the particulars of the allegations against the President have been substantiated. It has now omitted. The special committee is gone. So Rule 2 goes to 145.3 and then descends to B by plenary. It's saying the Senate may investigate by plenary. Where did this error originate in the making of our Constitution? My Lord, I go to that because if, suppose we are not making sense and our argument is too full of grammar, the theory of holistic interpretation requires you to look at the text, which we have done, and the history. What was the history? And how did we end up with a provision that, quote unquote, could sound difficult? My Lord, the theory of holistic interpretation is mainstreamed as a theory of interpreting our Constitution. Let us then travel back in time to the Bomas Conference. But my Lord, before I do that, allow me to draw your attention to a fresh new publication of the Senate, and that is a digest of the law and practice on removal of county governors and deputy county governors from office through impeachment. First edition, brand new, published last year. I apologize, I haven't yet produced it to the court. I intend to do that, but it's also available online, thanks to the Senate. My Lord, the Senate worries about this process. It says committee vis-a-vis plenary proceedings. And the Senate, this is about governors. It says that the law does not provide for any specific procedure. Page 104, a case digest.
Do you have it? Do you have it?
You do not have it yet. I've just apologized that I came across it yesterday because it's a new publication, but I will put it on record. When you turn to it and you look at page 104, you'll find that the Senate says that the law does not provide for any specific procedure. As a result, the county assemblies and the Senate are not bound to follow any route. That is what informs the rules of procedure, where the Senate may investigate. And that is also what informs Standing Order 80, where the Senate may use plenary to investigate. But, my Lord, the Senate recognizes what this court has in Sonko High Court. This court said that we are of the considered view that impeachment of a governor is a serious undertaking. The impeachment of a deputy president, of a president, is a more serious undertaking. For this reason, we recommend that it will be desirable in future impeachments to proceed through the committee route as opposed to the plenary. This High Court has recognized the inherent risks in investigating through plenary. Why? We say so because when the special committee is appointed, the Article 145(3)(a) committee, it has 10 days to deliberate on the matter, thus giving many opportunities to the parties to prepare their cases adequately. The committee gives the perception that each member is actually engaging in the process as opposed to the plenary, which can be perceived to be a mob lynching process. That's exactly what happened here. The investigation in plenary was a mob lynching process. The Senate goes on to say that trial by the committee, page 105, a case digest on removal of governors and deputy governors, a publication of the Senate, brand new 2025 Bond. Trial by committee gives the Senate, through the 11 members, an opportunity to review the usually voluminous documents from the governor's team. A trial by committee over the 10 days would have given the Senate the time to review.
In his written submissions, that decision is described as a decision of the Supreme Court, but it is actually a decision of the High Court. So that we don't have to later belabor this point now that he's addressing it, can he confirm? Because the written record says it is a decision of the Supreme Court, but it's actually a decision of the High Court.
I'm grateful that my learned friend, Mr. Mudomi Thiankul, a very good friend of mine, felt compelled to interrupt at this point, indicating its importance. It's an easy one. The decision is High Court, Sonko. There's a typo saying it's Supreme Court. It's High Court, but it's what the court has said. Now here, at page 105, where I was, the Senate is speaking to a member of staff of the Senate involved in this process. That's what this report highlights there. And this member of staff, I hope it's my learned friend, Ms. Thanji, is saying that trial by committee, the special committee under Article 145, 3A, gives members and would have given the deputy president's team enough time to interact with the senators on the voluminous record. Because of the fewer members, the committee is able to prod and follow up with specific questions, especially where the grounds for impeachment are technical. Perhaps the committee would have caught out that in Robert Alai, a case I was fortunate to argue with my learned friend, Mr. Ongoya, the court had already nullified Section 132 of the Penal Code on undermining the authority of a public officer. But this did not happen in this case. And finally, it records here that the plenary, it also says that there are some benefits to the plenary report as well. My Lord, in short, what you are saying is that the motion to impeach the deputy president was contingent on the special committee's report. It's not just procedural. There's also a substantive right given to him before that committee. Look at Article 145(5) of the Constitution. The deputy president has a right to be heard before that committee. The committee investigating the serious charges leveled against him. That step was omitted. That's a grave violation of the Constitution. My Lord, the final chance that he had to be heard was also denied to him, the adjournment. When something like that happened in a case that my friend, Professor Ojenda, Senior Counsel, argued with his usual merit, Onyango Law versus Kisumu County Assembly Service Board, 2025 Kenya Court of Appeal 333, the Court of Appeal was persuaded that Onyango Law had been denied a fair hearing. And just like in Oloma Law, the Senate here speedily approved the motion, skipped that special committee altogether, but retained the 10-day timeline. I wonder what the 10-day timeline was doing in a plenary setting where the Constitution does not impose that 10-day timeline, but requires reasonableness. It obviously can't delay until the end of the term, but that 10-day timeline was a stranger in the process. And so the Court of Appeal was persuaded that Onyango Olo was unfairly impeached. My Lord, we ask you to take the Onyango Olo decision and My Lord, whereas the special committee would have had the deputy president over 10 days, he was investigated in plenary over 24 hours and impeached in his absence. So I ask you again to take the Onyango Law decision, and where it says Onyango Law, please substitute Rigathi Gachagua and make your decision. My Lord, let me take you to the drafting history of our Article 145. It was not initially there as Article 145. And my Lord, the theory of holistic interpretation requires you to consider our social, our political, our historical context as a people. That history has names like Oginga Odinga, mistreated by the president, unfairly removed from office. It has Kungu Karumba, George Saitoti, at some point, not appointed at all, reappointed after the elections. I forget which year, I was a young boy then. But in your ruling of 31st October 2024, my Lord, you recognized this history and you said that the vice president served entirely at the president's mercy. That was a framework that the 2010 Constitution sought to transform. And under the 2010 Constitution, the office of the Deputy President is fundamentally redefined. Your words, it was safeguarded from arbitrary and capricious actions by the President. Before the Senate, on 16th October 2024, another good friend, Senior Counsel Otiende Amolo, a former member of the Committee of Experts who was familiar with the drafting history of Article 145, reflected as follows, and I quote, "Before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes." So my example of the color of his coat was not so far-fetched. It is on the Hansard record. My Lord, that's a correct reflection on the intention, on the history, on the motivations, on the framing of Article 145. In the National Land Commission versus Attorney General Supreme Court advisory opinion, the court held that unlike the Independence Constitution that failed to articulate the history and struggles of the people, the 2010 Constitution integrates that history and the people's view. And so, my Lord, when you turn to interpret Article 145 and you encounter the challenge with the may appearing in the second part of it, in 135 3b, and you wonder why does it appear this way, you must remember the history. Speaking of history, at page 182 of the CKFC final report, and that, my Lord, is a lawyer's Bible, it is a constitutional lawyer's Bible. It is the reference point for ambiguous text. We go back to it to see what was the intention here, what was the struggle, what was the mischief. The people said that, I quote, "there should be adequate mechanisms to avoid the risk of impeachment being used for purely political motives." Page 802 of that CKFC final report records that impeachment was one of the most contentious issues leading to extreme polarization amongst delegates. And the issue was not about the desirability of impeachment. No, it was about the procedure. What procedure do we use? Because we agree that the president must be amenable to impeachment. It is a remedy of last resort. But what procedure do we use? My Lord, In the Bomas draft that came out of that conference, the CKFC proceeding, we had Article 164. Article 164 of the Bomas draft is the exact replica of today's Article 145, except it had a bit more clarity. Why? Because the kind of Thank you, my Lord. My Lord, because the kind of contestations that attend the making of any constitution had not been there. Remember, by the time we are getting to 145, we've gone through a failed referendum. We've had the WACO draft. We've also had the Naivasha process that messes up and moves articles around. So back in Bomas, Article 164, this is what 164.4 said. If a motion is passed under Clause 3, Clause 3, the Speaker of the Senate is considering what has come from the National Assembly, the Senate shall appoint 13 of its members as a special committee in accordance with the standing orders to investigate the matter. So this committee was there, 164.4 Bomas draft. The special committee shall investigate the matter, 164.5 Bomas draft, and shall within 10 days. So the 10 days is also there. It's not a new invention under 145. 164 Bomas draft had it. And the president shall have the right to appear and be represented before the committee. So this right also to be heard before the committee was also there, 164 Bomas draft. My Lord, we then had the Guy draft, 163. This clause appeared at Article 163 of the Guy draft, and it also said that if a motion is passed under Clause 2, the Speaker shall constitute a special committee comprising the Chief Justice and 13 members of the National Council. So even when this committee was thought the Chief Justice should sit on it, it was there. When the name changed to National Council, the committee was there. It has consistently been there. Article 163.5 of the Guy draft provided that the President would have the right to appear and be represented before the special committee. So when it was Article 163.5 and not 145.5, the Deputy President's right to appear was there. I take you next to 2009 Harmonized Draft Constitution by the Committee of Experts. And my Lord, 163.4 of the Guy draft also required the committee to investigate. So its function was there, its composition changed a little bit, but the entitlement to appear before this committee and to be heard during the investigation of the charges was consistent. Article 170, 2009 Harmonized Draft. Now we are getting closer to the referendum. 173, upon hearing the charges under Clause 2, Article 173, 2009 Harmonized Draft, upon hearing the charges under Clause 2, the charges approved in the motion that has come from the National Assembly, the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter. So the number is now at 11. And the special committee shall investigate the matter within 10 days and report to the Senate whether it finds the particulars of the allegations against the President to have been substantiated. The President, you can guess, shall have the right to appear and be represented before the special committee during its investigations. My Lord, now we go to Naivasha. A constitution is a political charter. It will have vagueness of phraseology. Why? Because you need to get consensus and have the document passed, or you have no constitution at all. And so we take it as it comes, with ambiguity. But that's not the kind of ambiguity that scares this court. The court would be adept to interpret the Constitution together with those ambiguities understanding its history. Now, ambiguity is coming in. Naivasha, the Parliamentary Select Committee, a committee of politicians. They moved this clause to Article 127.3. And they're saying, upon hearing the charges under Clause 2, the National Assembly, now, they're also shifting it from the Senate. They're bringing it to the National Assembly, Naivasha. The National Assembly may, by resolution, appoint a select committee comprising 11 of its members to investigate the matter. My Lord, from 127.3, Naivasha, it gets back to 145, and it brings with it the May, which is there today. That's how it sounds vague. That's why it appears ambiguous. My Lord, throughout that history, the 10-day period is there. I am concluding, my Lord. The function of the committee...
I haven't said anything.
It's okay, my Lord. The function of the committee is also there. And the Deputy President's right to appear before it is there. And so, when on 9th October 2024, the Speaker misleads the House, telling it that you have two options. What is the source of that authority? Where does the Speaker get the right to amend the Constitution in his directions to senators? What gives him the right? It's not even in the standing orders. My Lord, he fuses, the Speaker fuses Standing Order 78, Standing Order 80, the Rules of Procedure, and Article 145. And in that process, Article 145 suffers violence.
Just clarify, you say that it appears ambiguous.
Yes.
Is it ambiguous?
It is not ambiguous. If you look at its history, if you look at its intention, if you consider that constitution making, Speaker of the Senate versus Attorney General, is a political process, it is quite clear. The Senate may appoint that committee if it finds that there's something to be investigated. My Lord, Blue Shoes, nothing to investigate, was the committee to investigate. But if there's something that appears plausible, there's something that needs some kind of investigation, then the Senate must appoint that committee. So the may turns to must. It must only appoint if there's something to be investigated. If it concludes that there's nothing to be investigated, the malicious compliance, if there's nothing to be investigated, it doesn't need to appoint the committee. My Lord, let me move forward and say that in Speak of the Senate, the Supreme Court explains precisely this kind of phenomenon, where the document born out of long-drawn negotiations, 2002, when I was a schooler, to 2010, when I joined the university, long-drawn process. The document is looked at, touched by many hands, including a number represented before the bar today. Constitution making requires compromise, which can occasionally lead to this kind of contradictions, where you have a shall in 145.3a and the may in 145.3b, and to those who are mischievous, it appears to be ambiguous. My Lord, political and social demands of compromise that mark constitutional moments fertilize vagueness in phraseology and draftsmanship. And when there's such, where do we turn? We turn to the court. And we ask you to interpret Article 145.3, considering the history I've laid out. Constitution making does not end with promulgation, it continues with interpretation. It is a duty of the court to illuminate legal penumbras that constitutions born out of long-drawn compromises such as ours tend to create. My Lord, the spirit of the Constitution has to be invoked by the court as a searchlight for illumination and elimination of these legal penumbras. My Lord, if this clause was so contentiously debated and nearly cost us the Constitution, how is it that the drafters could have intended that Senate can investigate these serious charges in plenary without saying so? How can such a serious provision be left to inference by a technical interpretation of the word may, that because it says may, that's discretionary? What about the and before the may? My Lord, how could the drafters have intended that Senate could investigate in plenary within 24 hours, even denying the subject of the impeachment a fair hearing? I turn to an issue of comparative constitutionalism. My Lord, no other country has a similar kind of fast-track impeachment that can be done in 24 hours. No other democratic country, at least according to my research. South Africa has the panel at Article 89 of its constitution. We call it special committee. South Africa calls it independent panel. The role of that independent panel, Section 89 South African Constitution, is to determine if sufficient evidence exists of a serious constitutional violation before the National Assembly votes. The role of this special committee was to sieve off some of these things that we are now confronting you with. Section 132 Penal Code, nullified. How can it form an impeachment charge? The United States uses the House Judiciary Committee to investigate the charges.
Precise object of the notice.
In Nigeria, Article 143.5 of the Nigerian Constitution, there's a panel of 7 members appointed by the Chief Justice of persons of unquestionable integrity, but who are not politicians or civil servants for independence. Panel of 7 appointed by the Chief Justice. If my learned friend Professor Ojenda were not a senator, but were a Nigerian citizen, he would sit definitely on this panel. In Philippines, Article 11, Section 3, it's called the Committee on Justice, this special committee. In South Korea, Article 65, the committee is called the Legislation and Judiciary Committee. It investigates the charges after a motion is proposed, though the Constitutional Court ultimately will adjudicate the trial. In India, Article 61, it's called Investigating House Committee. My Lord, the long and short of it is that what we had here was not a constitutional process that is worthy of this court's protection. If you faithfully interpret Article 145, if you just have one look at Standing Order 78, at Standing Order 80, if you look at the Rules of Procedure, Rule 2, and then you spend time, my Lord, with the history of Article 145, you will arrive at one inevitable conclusion. That is the conclusion that failing to appoint the special committee required by Article 145(3), my Lord, grossly violated the Constitution. And that violation was not harmless. It bogged the Senate down into a fictitious timeline. It said we are not appointing the committee, we have 2 options. No, they did not. But then they retained the 10-day given to that committee and said they're using that for the plenary investigations. What do you have? You have a sham of a trial. And in trying to punish the man Rigathi Gachagua in that way, the Senate and the National Assembly demeaned his office. They demeaned the office while trying to punish the man. And in demeaning the office, they, my Lord, grossly violated the Constitution. My Lord, thank you for the opportunity to address you.
Thank you. I think we have made good progress. We'll adjourn for lunch, then we'll come back at exactly 2.
That's right.
Changing procedures mid-process to suit the circumstances or the person under investigation. We are giving you, was it 10 days? Then midstream, we are going to continue, irrespective of whether you are sick or not. Rule of law questions. Can we operate a serious constitutional interrogation such as an impeachment in that manner? No, we say. Promote separation of powers. Structured procedures reduce institutional conflict by clarifying the roles of parliament, courts, and other bodies. Number 7, provides clarity and efficiency. Investigations and hearings move faster, are more coherent when procedural uncertainty is removed. Number 8, protects minority and dissenting voices. Those that dissent, and for aught we know, perhaps we had dissenters, people who are willing to vote against the impeachment. We may never know because the rules lacked. Formal rules ensure minority members in legislative bodies can participate meaningfully and are not outshot by majorities. It creates objective evidentiary standards. We had objective evidentiary standards from the courts. If that was applied in Parliament, that we don't know. But if that was agreed to in terms of rules, we will know what we are facing in terms of what evidentiary standard are we going to abide with. Finally, it builds a stable constitutional precedent. A predictable framework helps future impeachment processes remain consistent, credible, and less destabilizing to governance. A stable constitutional precedent can only emerge where constitutional values are treated as binding rules rather than aspirational rhetoric. If foundational values of the Constitution are understood as enforceable obligations, they naturally demand structured, predictable procedures whenever the most serious constitutional powers, such as impeachment, are exercised. In this way, fidelity to constitutional values become the anchor for consistency, ensuring that future impeachment processes are guided by principle instead of political expediency, and that governance remains stable, credible, and firmly rooted in the rule of law. The reasons for a rule-based impeachment process. There are no rules. In terms of the constitutional values at play, this court is going to make a decision for expediency. This is not just any other decision. Constitutional values are not decorative. They are not mere suggestions on the walls. They are binding obligations. These are our pillar stones, and these values that we have in the Constitution, such as the rule of law, due process, constitutionalism, accountability, transparency, separation of powers, are a must. They are inextricable. So when impeachment procedures occur without procedural law, clear procedural law, Parliament is no longer implementing the Constitution. It is operating outside it. And I dare confidently, with all the strength from my ancestors from Nyahera and Kisumu, say this, that impeachment is not a political ritual. It is a constitutional trial. May I repeat this for members of the National Assembly? My senator from Kisumu is here. Impeachment is not a political ritual. It is a constitutional trial. So without procedure, the process becomes arbitrary, And this directly undermines constitutional supremacy. That is one. Number two, the rule of law requires procedure. Power cannot operate in a vacuum. The rule of law means that power must be exercised through known, predictable, and fair procedures. We are extending time for you till Saturday. No, we are continuing with the impeachment immediately, irrespective of whether you're present or not. That is rule by man, not rule of law. Failure to have procedural law in the context of this impeachment meant this, that we did not have clear, predictable rules of evidence. That is one. The burden of proof, if at all it existed, kept on being a moving target. There was no right of defense. It was never guaranteed in the first place. People wanted to finish with what they wanted to do and move on. There are no clarity in terms of timelines, fairness, or impartiality. This creates a dangerous precedent where decisions depend on political discretion, not law. The process becomes rule by numbers, not rule of law. And in constitutional theory, absence of procedure means absence of legality. May I repeat that? Absence of procedure means absence of legality. Number three, impeachment is a quasi-judicial process, not a political vote. That term quasi-judicial has been used a lot here. But what is exactly meant by quasi-judicial? In my other life, I'm a member of the academy, and I see two senior members of the academy here. They can confirm that, and may God bless them in advance. Professor Jenda, Professor Githo Muigai, senior members of the academy. Quasi-judicial power means this, that this is the power to determine disputes or making findings affecting the rights of individuals, similar to the way courts operate. What was at stake during the impeachment? A validly elected deputy president of the republic was going to be impeached. His rights personally and the rights of his many supporters, those who voted for him as part of a ticket, were going to be affected. The consequences are there in terms of the quasi-judicial power. The removal of a deputy president being a very serious constitutional action. It has consequences for the electoral will of millions of voters, stability of the executive, continuity of government. And because of this gravity, impeachment must meet quasi-judicial standards. Quasi-judicial standards, these are the principles of good governance. I don't want to go through the whole list, but again, members of the academy, Professor Don Oliver has reduced the principles of good governance into four. Very quickly, these are legality, procedural propriety, rationality, and proportionality. The Oliverian quadrant: legality, procedural propriety, rationality, proportionality. When this court retires, we pray that you are going to consider those four principles. This process, as has been brought out by the first petitioner, do they meet the tests of legality? Do they meet procedural propriety in whatever guise? Does it mean rationality? Again, Professor Jenda should be familiar with Wednesbury degree rationality. That's a test.
Counsel, address the court, not the academy.
Most obliged. Most obliged. Most obliged. If I veer into the academy, please forgive me. Most of the time, I veer towards the academy. Wednesbury rationality. Has the Wednesbury rationality test been met in terms of this particular impeachment process? Proportionality. Look at the allegation on, for example, what was said and what ought to have been referred to the NCIC, the National Cohesion committee. Was that proportional? Does it meet the proportionality test? And on that very issue, Senior Counsel Paul Buite submitted to it. There's the principle of subsidiarity that is captured under Section 15 and Section 26 of the NCIC Act. Parliament ought to have deferred to the authority of the NCIC on the allegations made against the Deputy President. NCIC ought to have made the primary decision on the gravity or lack thereof of what was said. So the assumption of Parliament without going to the NCIC is not only illegal and unconstitutional, it also offends the principle of subsidiarity. When Parliament conducted itself in the manner it conducted itself, Parliament acted as the Hobbesian Leviathan. It became the investigator, the prosecutor, the judge, and the jury. This violates Article 47, principles of fair administrative action, and judicial action, quasi-judicial action. Procedural fairness protects the people, not just the office holder. Impeachment is often framed as an accountability of one individual, but constitutionally, impeachment protects the voters who elected that office holder. If procedure is absent or conducted in the manner it was conducted in this case, the electorate's choice can be overturned by unregulated political processes. This weakens popular sovereignty, a core constitutional value. Thus, the real victim of procedural failure is democracy itself. Whereas it protects, there are protections for the individual, the real protected target is the core principle of popular sovereignty. 5, the absence of procedure invites a constitutional crisis. Why? Because without procedure, courts are forced to intervene, parliaments claim political privilege, the executive legitimacy becomes contested. We have a deputy president who did not come through the ballot. That's a legitimate question. Institutional conflict arises between the arms of government. And this leads to the usual talk, judicialization of politics, politicization of constitutional processes, public loss in institutions. A constitutional democracy cannot survive when removal of national executive and office holders lack legitimate legal guardrails. 6, separation of powers demands legal boundaries. Parliament has the power to impeach, but not without limits. Parliament becomes a judge in its own course without procedural law. Checks and balances collapse. Majority power replaces constitutional restraint. Remember, we are a state under constitutional restraint, not abundant political power. The way in which this impeachment process was conducted contradicts the idea that constitutional supremacy restrains political majority. That is something we will invite you to find. The rules of natural justice, there are 3. The right to be heard, freedom from bias, and those have been submitted to. Then there's the 3rd rule, the rule in R versus Sussex, Justices Ex parte McCarthy, 1924. And this rule, as articulated by Lord Justice Hewitt, simply says this, that justice must not only be done, but manifestly and undoubtedly it must be done. Justice must not only be done, but manifestly and undoubtedly it must be seen to be done. In terms of this process of impeachment, the processes continued when the substantive subject of impeachment was in hospital. He did not have the opportunity to rebut or to respond to the charges. In terms of the 3rd rule, the first 2 were submitted to. I focus on the 3rd rule. R versus Sussex Justice Magistrates, justice must not only be done, but must be seen to be done. Do we see justice to have been done in this context when somebody was sick in hospital and processes continue without him being present? It's a problem. President danger, today's deputy president, tomorrow's democracy. If impeachment can continue and happen in such a shambolic manner that it happened, future removals will be done and can be done more easily. The threshold for removing elected leaders becomes political convenience. My brother Ochiel gave us the history. I don't want to go through it. Political convenience brought us to where we are in terms of shielding the office of deputy president. Executive stability becomes fragile. This transforms impeachment from a constitutional safeguard into a political weapon. Is that what we want in terms of this court? In terms of the jurisdiction of this court, I have completed with the rules of procedure. I want to go to the jurisdiction of this court. The High Court has 4 jurisdictional capacities under Article 165. The High Court has original jurisdiction, appellate jurisdiction, supervisory jurisdiction, and writ jurisdiction under Article 165. At play, particularly with regards to the matters before this Honorable Court, are the supervisory jurisdiction and the writ jurisdiction of this court. The supervisory jurisdiction becomes particularly important under Article 165(6), when supervising quasi-jurisdictional capacity of various arms of government. And this is where the court will invoke its judicial review power or judicial review authority. What is judicial review? Judicial review has 2 limbs to it. Judicial review is the primary judicial function to preserve legal order by confining the political branches to their proper limits of power under the Constitution. That's the first limb. The second limb is protection of private individuals by preserving or preventing illegal encroachment on the rights of these individuals. Those are the 2 capacities of judicial review. And when the High Court, under Article 165 of this Constitution, stands as the primary guardian and interpreter of the Constitution and its values, the court exercises broad authoritative jurisdiction, including supervisory and constitutional oversight over the National Assembly, so that the National Assembly will not be had to say that this is a political question beyond the reach of the court. This court, the breadth of its constitutional and supervisory jurisdiction is a capacity granted by the Constitution, and it's not an intrusion into the domain of the legislature, and is a necessary feature of constitutional design. I hear telepathically, and I can almost predict that you will hear this from the respondents, that Parliament has its right to formulate its own procedures. If the courts will be inclined to find it that way, we have provided to you a case, Maneka Gandhi versus Union of India, 1978. And it presents to this court a test. The Supreme Court of India, interpreting Article 21 of the Indian Constitution, speaks of due process in this manner. It says, number 1, that procedure as a capacity of due process must be established by valid law. That is condition precedent. That condition adds on to say that even if the procedure is prescribed by law, it should be fair, just, and reasonable. Fair, just, and reasonable. So when you retire to write your judgment, and you are satisfied that there was a modicum of procedure, you will have to look at that procedure in terms of the Maneka test. Was that procedure fair? Was it just? Was it reasonable? Was it reasonable to continue with process when somebody is at the current hospital getting treatment? That is a question you will have to answer. In conclusion, a determination of impeachment is not a routine judicial exercise. It lies at the crossroads of law, constitutional governance, and the stability of democracy itself. La santé de notre politique, as the French say, the stability of democracy itself. The court's voice in this moment is not confined to the litigants before it, but resonates to the nation and future generations. This is a modern moment. Your judgment will either confirm that constitutional authority is bound by the discipline of law, or suggest that the most serious constitutional processes may unfold without the safeguards of the Constitution as required. By carrying out this solemn responsibility, the court protects the supremacy of the Constitution, sustains public confidence in democratic institutions, and ensures that the exceptional power to remove a constitutional office holder is exercised strictly within the confines of the rule of law. Nunca más, never again, should we go to the dark old ages. I submit. My brother Sakimpa joins in next.
Thank you.
Yes, Your Lordships and my lady, my name is George Sakimpa. We do appear together with Mr. Ogada for the 4th to 8th petitions. Your Lordship, the petition that is before you is originally Kerugoya petition E015, and which has since been consolidated in these petitions. So, Your Lordship, I will only deal with 2 issues, because I do not wish to regurgitate what my seniors have already said. So, Your Lordship, I will just handle 2 issues, the first one being on the element of public participation, and it is going to be in twofold. That is from at the impeachment level, and secondly, public participation in terms of the appointment of the Deputy President, Professor Kithure Kindiki. And the second issue, Your Lordship, is on the Senate, and whether it was open for the Senate to apply the plenary route. So, Your Lordship, I will start with the first issue of public participation. Your Lordship, the principles of public participation have already been eloquently espoused here, especially the BAT Supreme Court case. So, Your Lordship, I will not delve into that, other than to add that there is an international association for public participation, which has since developed at least 7 core principles when it comes to public participation. Your Lordship, Kenya, under Article 2.5 of the Constitution, general principles of international law do form part of Kenyan law, and therefore we do rely on those provisions. And there are 7 principles, and basically they have been well captured in the Supreme Court case of BAT. So, Your Lordship, so I would not wish to mention the 7 of them, other than to be referring to them when it is necessary. So, Your Lordship, the most important element of this public participation is that it has to be qualitative and quantitative. So, Your Lordship, what I'm going to do in these short submissions is to go to the evidence and to actually demonstrate that the public participation exercise that was conducted on 4th and 5th of October 2024 were neither qualitative nor quantitative. So, Your Lordship, I will begin with the affidavit that was sworn by the 4th petitioner, that is Honorable David Munyi Madenge, where Your Lordship, in that affidavit, he says that he had no opportunity at all to participate in terms of echoing the views. And what was the reason for his inability to air his views? Your Lordship, the reason is that when he went to the designated center, Your Lordship, that center was closed. First of all, Your Lordship, the center was not open. It was closed, and there are evidentiary documents that were attached to his affidavit to confirm that that venue was closed. And that is what he has deponed in his affidavit, to the effect that he did not participate at all, because all the residents of Kirinyaga in that instance who went to that particular station did not participate. They dispersed without having given their views in terms of the impeachment of the second deputy president. So, Your Lordship, the next issue is on the issue of the notice. Your Lordship, from the notice, especially the extension notice of public participation, that notice was pursuant to the orders that were issued by Honorable Justice Richard Mwongo in a petition that was earlier filed, and where the judge said that the modalities that were put by the National Assembly were not sufficient, and therefore ordered for a second phase of public participation. So, Your Lordship, what the National Assembly did, instead of going back and preparing for a proper public participation as was ordered by the judge, they simply extended the public participation. Your Lordship, from the annexure that we filed, that is DMM1, Your Lordship, the notice is actually dated the same day when the extension was actually supposed to happen. So, from the daily newspapers that were filed, Your Lordship, it was on the very same day, that is on 5th of October 2024, telling the public that we have extended the public participation. So, Your Lordship, that notice was not enough, and even from the affidavits that was sworn by the 5th, 6th, 7th, and 8th petitioners, Your Lordship, they do confirm that they came to realize that the extension was given after, in fact, on the next day. So, in short, Your Lordship, because I don't want to repeat what my colleagues have already said, it is our humble submission that this court return a finding that indeed the notice was not sufficient for a meaningful and qualitative public participation. So, Your Lordship, on the other issue of quantitative aspect, my learned senior, Mr. Tom Masharia, had given a percentage in terms of the qualitative aspect, that out of 50 million Kenyans, only 200,000 gave their views in respect to the impeachment of the second deputy president. So, Your Lordship, that translates to 0.04%. And that is what basically said it's still 0%. So, Your Lordship, it was not quantitative and it was not qualitative. And Your Lordship, I only want to mainly emphasize on the decision that we filed, Law Society of Kenya versus National Assembly, 2025, where, of course, the court, in agreeing with the BAT case, the court said that public participation must be real. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. So, Your Lordship, I have already submitted that it was neither qualitative nor quantitative. So, Your Lordship, I want to go now to the next issue in terms of the public participation in respect to the appointment of Professor Kithure Kindiki as the Deputy President. So, Your Lordship, and I'll be referring to the memorandum that was signed by the President. And Your Lordship, we have it in page 1 of the affidavit that was sworn by Honorable David Madenge. It is page 1. So, and the document is a presidential memorandum of nomination by His Excellency the President William Ruto to the National Assembly. And it says that whereas pursuant to Article 150 of the Constitution, a vacancy has arisen in the office of the Deputy President. So, Your Lordship, in relation to that, our submission is that this nomination of Professor Kindiki was subject to the Public Appointments Parliamentary Approval Act, that is Cap 7F of the laws of Kenya. And Your Lordship, in respect to this particular act that I'm referring, the Presidential Memorandum of Nomination is substantially in compliance with the provision of this act, except on the element of public participation. That is where the National Assembly drew the line, that the memorandum of did comply substantially with the act, but they chose not to undertake public participation. And I will start with the objective of this act. So, and the act says it is an act of parliament to provide for procedures for parliamentary approval of constitutional and statutory appointments and for connected purposes. So, Your Lordship, from the memorandum by the President of nomination, it is clear that this is a constitutional appointment, because he actually says that pursuant to the provisions of Article 150, a vacancy has arisen in the office of the Deputy President. So, in essence, Your Lordship and my lady, this is a constitutional vacancy and a constitutional appointment that was subject to the provisions of the Public Appointments Parliamentary Approval Act. And Section 3 of that Act says that the exercise of powers of appointment. So an appointment under this Constitution, that is Section 3, an appointment under this Constitution or any other law for which approval of Parliament is required shall not be made unless the appointment is approved or deemed to have been approved by Parliament in accordance with this Act. So, Your Lordship, it is clear that the appointing authority in this case was the President. So after appointing Professor Kithure Kindiki as a nominee for the position of the Deputy President, it was subject to the application of this Act. And as I said, Your Lordship, the memo complied completely in all aspects with this Act, save for public participation. So, and Section 5 also provided for notification of nomination. And it says that an appointing authority shall, upon nominating a person for appointment to which this Act applies, shall notify the relevant House of Parliament. So it is through this Presidential Memorandum of Nomination that Parliament was notified of this appointment of Professor Kindiki. And it further says that a notification of appointment shall be accompanied by information concerning the nominee having regard to the issues mentioned under Section 7. So, Your Lordship, I am sure that you will have an opportunity when you retire to examine this presidential memorandum. And in fact, it does highlight that the President says that for reasons whereof I have enclosed the following documents, and which Senior Counsel Paul Mwite said that it was done in an ungodly speed. So, Your Lordship, I want to reiterate that the essence of this Act was provided by Parliament so that it provides safeguards, especially on the issue of public participation, where the citizens will be given an opportunity for them to give views on the new nominee. And that is the procedure even in terms of the appointment of cabinet secretaries and all the appointments that are made under the Constitution. And Section 6, which is the most important part, it says that the committee, Section 6(4), approval hearing. So the committee shall notify the public of the time and place for holding an approval hearing at least 7 days prior to the hearing. So, Your Lordship, 7 days prior to the date of the hearing. Your Lordship, of course, from what we've heard is that the impeachment was done on the 17th of October, and on the next day, that is when the President forwarded this memorandum of appointment. So, Your Lordship, from that moment, the law requires that before the approval was done, the public had to have been given a notice of at least 7 days. So, Your Lordship, and the President further says, in forwarding this nomination, that, and he quotes Article 149 of the Constitution, which says that within 14 days after a vacancy in the office of the President arises. So, Your Lordship, within 14 days, of course, this was done within a few hours. It was, the impeachment was done at night, and in the morning, the President did this act. So the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. So, Your Lordship, under Article 149, the Constitution gave 60 days for Parliament to consider the appointment of the new nominee. And the reasoning, Your Lordship, is that these documentations that have been given by the President forwarding the nominee, Parliament was under an obligation to consider those documents within a period of 60 days. Your Lordship, by midday on 18th of October, Parliament had already voted on the issue of appointment of Professor Kindiki in complete disregard of Section 6.4 that required the public was to be given at least 7 days so that they can give their issues in terms of the suitability of the Deputy President nominee. Your Lordship, but obviously that was not done. And Your Lordship, I'll also now refer to the response that the National Assembly, in their submissions, they have filed, or rather they have given a ridiculous response to these submissions that we made. And under paragraph 361 of their submissions, they say that, in fact, this was a sui generis, it was a sui generis procedure, to the effect that it was not an approval, but a vote by the National Assembly. Your Lordship, assuming even we take the argument that they say that in fact it was a vote and not an approval hearing, Your Lordship, then the provisions of Article 118 of the Constitution will then apply, because they will still need to conduct public participation as required under Article 118. And Article 118 provides that public access and participation. So it says that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So, Your Lordship, even if they escape the provisions of Section 6.4 of this Act, of the Public Appointments Parliamentary Approval Act, then they cannot circumvent the provisions of Article 118, which requires that Parliament must still, in all its businesses, involve the people. And Your Lordship, there is an authority that I want to rely on, and that is Legal Advice Center and two others. It is in our case, in a bundle of authorities, versus the County Government of Mombasa and 4 others. It's a 2018 decision. And Your Lordship, I just want to quote in verbatim a very small part where the court said that the purpose of permitting public participation in the lawmaking process is to afford the public an opportunity to influence the decision of the lawmakers. So, Your Lordship, assuming that we were to take the proposal that they said that this was a vote that ought to have been taken by the National Assembly, then under Article 118, they must have sought public participation before they made the vote to approve the Deputy President nominee. And Your Lordship, they further give a fallacious explanation and say that actually it is equal to the election of the Speaker and Deputy Speaker and members of the regional parliament, that is IALA. So, Your Lordship, that is not true. In this case, this nominee is directly appointed by the President, and there is a memorandum of presidential appointment. In the case of a Speaker and members of the East African Legislative Assembly, they are directly elected by Parliament, or rather in whichever house that is applicable. So there is no nomination that happens by any authority in terms of before the Speaker is elected. They are directly elected by the members of Parliament. So, Your Lordship, the last issue that I'm going to discuss as I conclude is on the issue of whether the Senate violated Article 145 in terms of taking the plenary route. Your Lordship, our submission is that it was not open in law for the Senate to take the approach of the plenary. And my learned senior Ochiel Dudley had already discussed Article 145.3. So, Your Lordship, I will not belabor on that point, other than to submit that under that provision, that is Article 145.3, where it says that the Speaker of the Senate shall convene a meeting of the Senate to hear the charges against the President, and the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter. So, Your Lordship, even if we were to apply all the statutory, or rather all the interpretations, rules of interpretations of the Constitution, all of them will point to the position that the appropriate route was the special committee. And Your Lordship, there is, the first rule is the literal, of course, interpretation of this provision. It is clear that from the reading of that provision, there is nowhere in which the framers of the Constitution provided that a plenary session can be held to investigate into the conduct of the Deputy President. And in fact, Your Lordship, from Article 145, it is clear that the Constitution was very clear in terms of the impeachment of the President, because it does apply to the President, and of the Deputy President. It went further to actually provide what needs to happen. And it is a constitutional buffer that was put there to ensure that whoever is undergoing the process of impeachment will get the benefit of the law. And I will shortly be reading the provisions of Article 27 of the Constitution, where it actually provides for equal benefit of the law. And maybe I can just quickly, as I finalize, read section 27(1), which provides that every person is equal before the law and has the benefit and has the right to equal protection and equal benefit of the law. So, Your Lordship, under Article 27, there is a benefit that has been, under Article 145(3), there is a benefit that has been put there by the Constitution, and which the second Deputy President was entitled to benefit from this provision of the Constitution in terms of having a special committee to investigate into the allegations that were leveled against him. So, Your Lordship, and if we look at actually that provision again, if we were to take the position that actually a plenary is also a route that is provided here, it will actually amount to a discriminatory act in the following sense, my Lord and my Lady, that it means that the Senate will be deciding, there is no criteria as to when the special committee will be applied by the Senate and when a plenary will be applied by the Senate. And Your Lordship, what that means is that it will depend on whether the Senate actually, you are in good books either with the Senate or whoever who is in charge of those impeachment. Because there is no procedure that actually provides that under these circumstances, a special committee must be undertaken, and under these special circumstances, then the plenary can be undertaken. It is left to the Senate to determine at whichever time they are going to use whichever mode. And Your Lordship, that has been demonstrated even in the impeachment of governors, where you find that some governors are subjected to the plenary, others are subjected to the special committee without any justification why this was used over that. And therefore, the purposive interpretation and holistic interpretation of this article will yield a conclusion that at all times when it comes to the impeachment of the president or the deputy president, a special committee must be constituted by the Senate for purposes of hearing, investigating, first of all, whether the charges have been substantiated before a recommendation is made to the Senate. And finally, the other rule that I want to rely on is on the Latin maxim that expressio unis est exclusio alteras. So, Your Lordship, that provision basically means that what has been expressly provided under the Constitution, any other thing is excluded. Your Lordship, the framers of the Constitution, if they wanted to have both modes available, then, Your Lordship, there was nothing difficult in them saying that either they investigate by the committee or by plenary. They expressly excluded the provision of a plenary, because what the Constitution wanted is a process where the president or the deputy president is given an opportunity to, first of all, for the Senate to first of all investigate by the committee, and finally that the matter be deliberated in the Senate. So, Your Lordship, in light of those brief submissions, we do pray that this Honorable Court finds that the impeachment of the second deputy president was unconstitutional, invalid, and null and void. Those are my humble submissions.
Can you in just 1 second tell me the remedies we're seeking in this petition?
Yes, Your Lordship. In our petition, we have several prayers that we've sought, and the first prayer is a declaration that the appointment of Professor Kithure Kindiki as the Deputy President of the Republic of Kenya was invalid, null and void for the reasons that we've given in terms of there was no public participation. Your Lordship, another prayer that we did seek is a declaration that the National Assembly and the Senate were under an obligation to undertake separate public participation in respect to the impeachment of the second deputy president. Further, Your Lordship, another prayer that we sought for a declaration that the public participation that was conducted by the National Assembly on 4th October and 5th of October was not proper, effective, and meaningful within the provisions of Article 10 and 118 of the Constitution. And finally, that the impeachment process of the first interested party, being the second deputy president, was invalid, null and void. Those are the submissions. And Your Lordship, of course, cost of this petition.
Thank you very much.
And we do support the position that was taken by the first petitioner. Most obliged, my Lord.
Thank you. Mr. Umoke.
Your Lordship, I would like to present my petition on a fresh day. So I'll let Ms. She can go ahead.
Are you revising the directions which we made without application?
No, Your Lordship. I would like for the second petition, she can proceed.
So why do you want a fresh day?
No, I can still carry on today.
Yes, my name is Teresia Wanjiru Kimoto Makazi from TES Kimoto and Company Advocates Kerugoya. I'm for the second petitioner. So my petition is the one dated okay, thank you. It's the one dated 25th September 2024. And in that petition, we are seeking several orders. And in those orders that we are seeking, one, we are seeking that the then Honorable Rigathi Gachagua, there be a declaration that the constitutional rights of the applicant, who is the petitioner, provided for under Article 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. And that the first respondent, who by then was the current Deputy President, be ordered to issue an apology to the NIS members and staff due to the utterances and speech made on the 26th June 2024. Cost of the petition and any other relief the court may deem fit. Of course, we wish to say that our petition has not been opposed by anybody. Let me finish. And we rely, of course, on the facts in support of the petition and our supporting affidavit as it is. We also wish to say that the reason why we had done an application to stop the impeachment proceedings is because...
I don't like doing this. But clearly, Ms. Kimotho's petition is overtaken by events. The petition sought an apology by the second Deputy President to the NIS. That did not happen. The impeachment occurred. A vote was taken on that question, and it is the subject of the first petition argued by Senior Counsel Paul Mwite. So Ms. Kimotho should sit down. Thank you.
No. We are opposed to that because that's not true. The apology we were seeking is an apology from the Deputy President, whether he's sitting or not sitting. So we are very much in place. And again, we also wish as I proceed, before I was interrupted by my senior, I wish to say that we are also in support of, we are against the process of impeachment. And we are going to say why, if I'm allowed to say. The reason why we are in support of, why we are against, the impeachment process is that the grounds that we relied on in our petition are the same grounds that were being litigated by the Senate. The judge, when we went to, our petition was first, E013. When we went to the High Court at Kerugoya, we raised these issues. The Senate had not yet started the process, the impeachment process. And so we felt that if we were hard fast, then this whole issue would have taken a different turn. Because once a case is pending in court, once the issues that are being raised are the same issues being raised in the Senate, then we ought to have been hard fast. And that's what we have been raising from the application that we did, and even in this situation when we are arguing our petition. We again say that if you look at the entire process, any person who goes to court must be heard. That's an Article 50, fair hearing. Then if the same issues that are being raised here are raised there, then of course there's an issue. It shows the senator, because we served the Senate, and the Speaker clearly acknowledged that there's a petition going on in Kerugoya, but they ignored. This can only show their minds. They had made up their minds. And that's why now we are in support of the petitioners against the entire impeachment process. And this point is very, very important. Again, if you look at when we were consolidated, there came the issues again that are being raised here. Public participation, which on our part, we are supporting. We are saying the public participation that was done was not done well. His Excellency Rigathi Gachagua, His Excellency the President of Kenya, William Ruto, are people who were voted by Kenyans as a duo, not individually. So now when His Excellency, one duo, one person, one part of that duo is subjected to impeachment without the same process that was used to bring them to power, then that issue violates the Constitution. And why are we saying this? If you look at how they were elected, polling stations were everywhere. Each constituency, each polling stations in the wards, people were allowed to vote. So now when it comes to public participation, in where now we want to remove one duo, why are Kenyans not being told, come, let's get your views on the removal of one duo that we elected? How can we be told we don't have a right to be here right now? We do have a right, because if Kenyans did not participate equally as they did participate during the elections campaigns, then the process, any public participation that is said was done here was a sham. The second issue, why we are in support of these petitioners. Again, you can see how, and these are allegations that are in public domain. In fact, in our petition, we are accusing the Attorney General of these issues. Everybody kept on saying the MPs were given 500,000. The senators were given 1 million. These are allegations in the public domain. Can we say this process was fair when people out there are claiming there is bribery? We have seen several talk shows, people continuing saying these issues. So we are objecting to that process that was done. The other point that we wish to say is, okay, again, that was repeated, but I can emphasize, on the day of the Senate, we see the then Deputy President, Rigathi Gachagua, falling sick. We have served, there is our order, standing there, the Speaker of the Senate acknowledging that yes, we've been served with an order. Then suddenly the Deputy President becomes sick. And then what happens? The Senate does not care. They give a few hours, a few days, and then say, we will proceed, whether he appears before us or not. We go back to Article 50, fair hearing. Fair hearing means, however that person is, he must be allowed to give us his side of story. Kenyans were waiting. Kenyans were watching the TV. They wanted to hear His Excellency Rigathi Gachagua tell us, we voted for him. We want to know what happened. What happened, yet we voted a duo. So this chance we were not given. What we saw was in Senate, people come in and the lawyers speak and other allegations, paperwork. So Kenyans would have expected to hear his side of story. So in that, we say he was not given a fair hearing, and therefore that impeachment process was not conducted the correct way. Yes, I think my points, those are my few points. They are very fiery, so I don't want to keep...
Of course they are.
Yeah, I don't want to spoil anything. That's all for me.
Thank you. They are fiery. They are fiery. Thank you very much.
Okay.
Yes, thank you.
My Lord, Tess forgot to say that Kerugoya is in Kirinyaga.
Oh, yes.
Correct.
Can we see how many people are yet to submit? How many?
My Lord, there's the third petitioner.
Mr. Kibe. Where is Mr. Kibe? Can I see how many are yet to submit? So we'll proceed until 6.
Did your Lordship give an indication of up to what time we will be sitting?
6. 6.
Today?
Yes. You want us to amend it?
No, I was just asking for clarity on up to what time today we will be sitting.
You know, these people, I don't know where the councils have arrived from, because when we were taking quorum, they were not this large. Some people have just appeared. Some of the councils have just appeared now, because you spoke about 8 people. 8 councils, yes. And then after that, we have had now, I see quite a number of councils are here. I don't know, maybe.
Probably a misunderstanding. The 8 council I stated are the 8 council appearing for the first petition. There are many other petitioners, and these council are for those other petitioners.
Yes.
But looking at the number, it's a matter entirely in your Lordship's
So we can do up to 6. Then after that, we can make further directions.
Okay.
Yes.
Thank you, my Lord.
My Lord,
My Lord, just so that I may get some clarity, the 2 of us going, 6 o'clock, that's in 30 minutes. It would be better if we took a proposal to get directions from the court, because I would definitely need more time. Unless maybe I might be lucky that there's one of us who can do it in 30 minutes to make 6. Okay, he's willing to do 30 minutes.
Okay.
Your Lordship, once again, my name is Morara Moke. I am the 43rd petitioner. I filed a petition on my own behalf, and I was deeply offended by the manner in which the impeachment process was being conducted. And therefore, in compliance with the Constitution, I came before this court to defend it. It was not about my political alignment at the time, but about the Constitution, and that's why I'm here today. My petition is E027 of 2024. I have a supporting affidavit sworn on 9th of October 2024.
E0?
Sorry?
E047?
E027 of 2024. The same date. On the same date I saw the affidavit, 7th of October 2024. I filed very brief submissions dated 1st of April 2026, in which I sought to address 2 issues, as I do not wish to repeat. what the first petition has already submitted on, but I fully support the submissions presented by the councils for the first petitioner. And I will proceed to make a few additions. On the issue of public participation, I personally attended the public participation exercise at Kiambu Social Hall. I'm a resident of Kiambu County, although I'm born in Kisii. I attended, and I can confirm that the form that was provided to the participants only summarized the allegations against His Excellency Rigathi Gachagua without provision of any particulars or any evidence in support. So I can confirm as a participant, and there is no response in opposition to my petition to challenge that position. There was no evidence in support of the various grounds of impeachment as presented to the public. Secondly, there were no attachments of His Excellency Rigathi Gachagua's response, which at the time had already been filed before the National Assembly. It was never provided to the participants. And as earlier on stated, the public was only being asked to give an opinion of yes or no, and only a very small provision at the bottom of the form to say any other thing. I also would like to indicate that the manner in which, rather the form, the language was only in English. And as you know, in this country, we have two official languages, English and Kiswahili. Earlier on in Swanya's submissions, he did talk about the BBI case. Actually, in that case, I prosecuted that point on providing different languages when it comes to public participation, especially on an issue that is so important as this impeachment. It was only done in English. There's no explanation why it was not done. They could have taken time, but because there was the hastiness with which this process was being carried out, of course, there was no attempt to provide for any other language. In my petition, I gave a background to the impeachment process, and I did find fault with the lack of partiality on the part of the Speaker of the National Assembly and the Deputy, and the remarks they made prior to the impeachment process. Starting with the Deputy Speaker, she did say, mimi mwenyewe nitampeleka nyumbani in a public rally. Around the same time, the Speaker for the National Assembly even quoted a verse from the Bible about getting rid of something that is considered to be inappropriate in reference to the Deputy President, even before the impeachment motion was presented before the National Assembly. And this, as we said, while they do not vote in an impeachment process, they preside. So it is extremely important that the two individuals who have the mandate of presiding over the impeachment process ought to act with impartiality, and they have to have no bias. And I would have to say that the two of them totally failed, and that vitiates, in my opinion, in my own submission, that vitiates the entire process. They should have refrained. They could have been more restrained in their remarks, even if that's what they believed. But they totally rendered the process unacceptable. I'll come to another issue. In the manner in which the grounds of impeachment were debated, and you look at the Hansard for the National Assembly, I'll make reference. I've seen multiple copies, but there's a copy before the court, I believe. I would ask you to look at page 18.
Which dated?
The Hansard is in reference to the impeachment proceedings. I believe it should be before. Without it before this court would mean that I'm not able to point out the specific date, but it should be before the court.
We had two.
The one for the National Assembly. I'm making reference to the one in the National Assembly. It's 5th of October, 2024. Sorry, Your Lordship, 8th of October, 2024. In that particular Hansard at page 18, I picked the remarks that were made by the Member of Parliament for Suba South, Karoli Omondi. At page 24, I picked remarks that were made, I believe those were made by Honorable Catherine Omanyo. And also, I'll take the two of them. So they went ahead and introduced other issues. Also, I forgot to mention the Member of Parliament for Mavoko, Patrick Macau. Actually, that is at page 24. Then at page 42 and 43, you will find those of Catherine Omanyo. I will not go into what they said, but I would ask the court to look at some of the issues they said, which to me were personal issues they had with the Deputy President, or some long-held grudges, which they used as their reasons for endorsing the advancement of the impeachment to the Senate. This being an impeachment trial, which, as we said, in the standard set in the Wambora case, which requires a very high standard, and the Constitution, which also talks about grossness and seriousness of the misconduct and the violation. You cannot introduce any other ground, even if that's what is your reason. You have to debate, you have to vote on the impeachment on the basis of the grounds that have been stated in the motion. So that is another failure, which on that basis I would ask the court to find that the impeachment failed to meet the standard, the constitutional standard. It has to be the constitutional standard and threshold, and therefore it ought to be declared null and void. Your Lordship, I would now move to present on the issue of lack of legal mechanisms, or rather legislation, to operationalize Article 150, in this case, of course, which incorporates the other articles on impeachment. Again, on this issue, I did make a presentation in the BBI case on the lack of legislation. In that particular case, the issue was lack of legislation for collection of signatures. And that was an important issue in the BBI case. And the court agreed, and I would ask this court to make that finding, which is extremely important, that this kind of a process, being so important, must have legislation. And I would like to state why it is important. For instance, when you look at the provisions touching on the election of a president and a deputy president, it's very clearly provided on the judicial review available to any party who is dissatisfied with the process. It's elaborate. It has to be that you come before the court, you raise your issues, the court makes a decision. Thereafter, then whoever is elected is sworn into office. So the Constitution, in a way, has actually enforced some conservative relief. However, that is not provided on the issue of impeachment, and therefore, just as important as the process of occupation of that office, so should be the process of exiting that office. And that, therefore, would require legislation to address that issue. Before this court, we argued on the issue of conservatory orders. Your Lordship, it leaves us in a difficult position if this court was to find that this impeachment process was unconstitutional. How do we cure the fact that His Excellency Rigathi Gachagua was hounded out of office, replaced, and now he's left without a solution? Because if we say, for instance, that if we were to order him back to the office, the kind of situation we face is difficult. And that is why it's important to have legislation to provide for room for judicial intervention before the swearing in of the new occupant of an office, if the court was to ever confirm the impeachment process. It also would also aid the person, the incoming, not to come in under the cloud of illegitimacy. Because as we are here today, we have issues have been raised by my colleagues about the fact that the replacement came into office hurriedly without any safeguards. There was no vetting. Because being an appointee, then it reduced him to that level of requiring vetting. While for an elected deputy president, the vetting is with the people. They vet and they vote. So I would say that this is an issue that leaves us in which actually paints a cloud of doubt on the efficacy of fair hearing in the Constitution. And my hope is that the judiciary would acknowledge that the fact that we did not have conservatory orders in place was a problem. And I would explain why. In the Constitution, there is a line of succession provided that if the president is not there, the deputy president would come into office, would act in that period of vacancy. If the two of them are absent, there is a Speaker of the National Assembly. And the fact that in the ruling on conservatory orders, we did recognize the significance of this office. Therefore, it will become so important if we had legislation to even provide for such situations. What should happen? In my petition, I have only asked for 2 reliefs: a finding on the unconstitutionality of the process, and on the question of a lack of legislation, which as I submit before this court and ask this court to align with your colleagues in the BBI judgment, that lack can render this kind of a process flawed. I so submit to your lordships and my lady.
Thank you.
My lords and my ladies, I see it is around 5:50. I'd requested court for 20 minutes, but based on what has been submitted, I'll only take 10 minutes because I wish not to repeat and regurgitate what my seniors and the petitioners who have come before me have already told this court. Your Honor,
I don't think we'll be able to hear you now because there's another petition we are mentioning and time is well spent. Just give us a few minutes, we'll give you directions.
Much obliged.
So I think our time is well spent. We have to adjourn to the next hearing date, which is 7th of May. We'll proceed with the petitioners' counsel who have not submitted, and thereafter we will proceed with the respondents on 7th of May. Should I suggest that we start at 9? Yes, 7th of May at 9. So with that, I think, yes?
No, I was waiting for my lord to finish giving the directions.
Yes. Yes, I've finished. We'll adjourn until 7th of May at 9. By that time, I think we'll have the services of the ceremonial hall. So we'll be in the ceremonial hall.
My lords, on behalf of the entire bar, I wish to thank the court for the patience with which the court has listened to those who were able to address the court today. Secondly, I forgot to point out that the petitioner, His Excellency Rigathi Gachagua, has been present in court as he's entitled to, together with his friend, my colleague, Honorable Eugene Wamala. I thank the
Thank you. Thank you very much.
My Lord, I know that I should not go after my pupil master, Mwita Senior. But my Lord, just for the record, when Macharia submitted, he referred to senators as goons. And I hope that must be struck out of the record.
I think my colleague Tom Macharia. My Lord, through the code.
Excuse me.
Tom Macharia was talking
please.
about what you might have organized in Kisumu.
Excuse me, please. We want to confirm whether we had that.
Yes, my Lord. He said.
It does not appear in my record.
Yes, he said that democracy, that parliament, that the vote that is tantamount to goonship in the legislative process. He did. And the senator for Kiambu is here. He's not a goon.
This is how they impeach the deputy president on their own record, imaginary record.
Thank you.
My Lord, with your kind permission.
Yes.
My matter still is yet to be mentioned.
Yes.
E586. And my Lord, I would have been much more happier now that my love friends are here. In fact, I would have submitted, and how beautiful it would have been, because the memory of it would just have lingered. So that, my Lord, but the petition got separated. It's now floating out there.
You separated yourself.
My goodness. My Lord, I do appear for the petitioner.
Where is the file?
Yes, my Lord, Harrison Kinanjui. I appear for the petitioner.
Yes.
I believe there are some of my learned friends here appearing for the respondents.
This is petition
E568.
E568 of 2024. Joseph Enoch Aura versus the National Assembly.
Lord, I don't know why Mr. Gumbo now is escaping from. I was leaving the floor to him.
Thank you very much, Harrison. I was waiting, my Lord, for the matter to be mentioned. I appear in that matter. My name is Gumbo Eric. I do appear with my learned friend, Mr. Paul Nyamodi, for the first and the third respondents.
For the record, my lords, I appear for the fourth, fifth, and sixth respondents, together with my learned friend, Mr. Mukele and Ms. Thanji from Senate.
My Lord, my name is Mudhomidin Kolu. I appear for the 10th respondent, together with Messrs. Moses Kipkogei, Kennedy Mele, Boniface Mawera, and Kenson Mutethia.
Good evening, my lords, my lady. In the matter, my name is Dennis Nkarechia. I'll be requested to hold brief for Ms. Joy Anami, Mr. Mahat Somen, and Mr. Nura Hassan, who are on record for the 9th respondent, the IEBC.
Yes.
My Lord, we do have the interested parties, but the interested parties did not take, should I say, interest in the petition. So I think it can just be marked as absent. My Lord, we were supposed to appear before you on Friday last week. However, for reasons explained to us, it was not possible, by reason of which the petition then was deferred to today. My Lord, you advised that I come at 10, and I have been just lingering here. I'm probably one of those advocates that you said you haven't seen, but we were outside there, and we seem to have flooded your courtroom all of a sudden. I don't wish to take too much of your time. You've spent the whole day here, Your Lordship, my lady. And therefore, I would beg that you give us directions on the way forward. Although, I should add, we have sought the intervention of the Court of Appeal, excuse me, my voice a bit.
Good afternoon to your ladyship and my lords. Ms. Chair, the first respondent, petitioner, together with my colleagues. I will address you on the question of the remedies available and on the question of jurisdiction raised by the respondents. My lords, and it's important so that we understand what is in dispute and what is not in dispute. The respondents in their submissions, and by this I refer to the submissions by the first respondent, they ran to over 120 pages and are dated the 17th of September 2025. We have today received submissions on behalf of, I believe, the second respondent and the eighth, the speaker. No, actually the first respondent, that's the speaker of the National Assembly, and the eighth respondent, the deputy speaker of the National Assembly. In their joint submissions, this, in summary, is the case they intend to put forward and which will be the basis upon which they will be asking you not to grant the orders I am about to beseech you to grant. At paragraph 95, they begin by making concessions, which is always a good place to start. They concede that public participation is necessary for purposes of the impeachment proceedings that are before you. They concede that judicial oversight is within the powers of this court as regards the impeachment proceedings. They then muddle up their submission somewhat at paragraph 107 by stating that impeachment is a purely political process rather than a judicial one. At paragraph 107, they seek to limit the purview of this court's mandate by stating that the court review of the decisions or the process does not include interrogating substantive merits of the impeachment charges. They, however, concede at paragraph 109 that this court has jurisdiction and power to examine whether the constitutional and statutory procedure for the impeachment was followed lawfully. That's paragraph 109. They concede as well at paragraph 109 that this court can examine the question as to whether the petitioner's rights were violated. I believe they are citing a decision of the Court of Appeal in making that concession. They then repeat at the same paragraph that the court cannot reevaluate or substitute or interrogate the substantive merits of Parliament's decision. And I'll be demonstrating to this honorable court why that is not the correct position. Having conceded that public participation is necessary, as they have at paragraph 95, they then seek to somehow circumscribe their concession at paragraphs 292 and 294 by saying that Senate did not require to conduct public participation. It's the boldest statement negating public participation I have ever had by a state organ. At paragraph 183, they make the point that fairness is required as a part of the process and that it requires careful consideration. And as regards what my learned senior counsel, Mr. Paul Muite, alluded to here earlier this morning regarding the events of the night when the IBC was consulted leading to the nomination of the current Deputy President. They make the point at paragraph 380 that the National Assembly was not conducting a normal vetting process. It was a vote. In fact, they make the point that it was an election. Those are the words they use. And this is now to be found in the submissions of the first and eighth respondent at paragraph 68 to paragraph 70, that the President, in consulting IEBC on that night, was not doing so as a matter of constitutional requirement, but was doing so as a matter of abundant caution. He was being careful. He didn't require to do so. Those are the points they make. Now, this court is imbued and clothed with authority, first and foremost under Article 22 of the Constitution of Kenya, and I don't need to read all the remedies that are set out therein. But among those that are set out there and relevant to our client's case, one is compensation, E, and F, an order for judicial review. And then at Article 165, Subarticle 6, the High Court has supervisory jurisdiction where it is examining a decision arising from a quasi-judicial proceeding. And this is important for reasons that I will make known shortly. Now, I call this court's attention to Section 11 of the Fair Administrative Action Act, and it's an important act for many reasons, because whereas Parliament has made very lengthy submissions on many things, Parliament constitutionally talks through the laws it passes. This is a law Parliament passes directing what is to be fair in a proceeding such as this. And I begin first by making the point, and the respondents agree with me on this, and I'll be demonstrating where the submissions. They say that the Senate proceedings were quasi-judicial. That is the word they use themselves. And perhaps I think I should actually identify the exact paragraph where they say, I believe this is paragraph 292 of their submissions, where they say that the Senate was exercising a quasi-judicial authority. Yes, indeed, at paragraph 292 of the submissions by the National Assembly itself. And this is what they say. We submit that the Senate's function under Article 145 is not a legislative function, but a quasi-judicial and adjudicative role. The words quasi-judicial are the same words appearing, as I've stated, at Article 165, Subarticle 6. But perhaps more importantly, under Section 2 of the Fair Administrative Action Act, and the Act begins by stating, this is the rationale for the statute by Parliament itself, this is an act of Parliament to give effect to Article 47 of the Constitution of Kenya. And this is what they say. Administrative action is defined as the powers, functions, and duties exercised by authorities or quasi-judicial tribunals. And so, by concession, by admission of the Senate, the decision, the process they undertook was quasi-judicial and therefore amenable to the Fair Administrative Action Act. And this is important because at Section 5, the statute says that in any case where the proposed administrative action is likely to materially and adversely affect the legal rights or interests of a group of persons or the general public, it then says what must be done. Amongst the first things that must be done is that there must be the issue of a public notice of the proposed administrative action inviting public views in that regard, public participation. Senate was required by the statute, by Section 5, to conduct public participation. They have admitted they did not do so. Number two, they are to consider all views submitted in relation to the matter before taking the administrative action. They were to consider everything said to them during public participation. They elected not to do so. They are to consider all the relevant and material facts, and D, where they proceed to take their action, they are to give reasons for the decision of the administrative action as taken. Again, they did not do that. That was not done. Now, and my good and learned senior here, Mr. Swanya, will be coming to give a few more details on the question of public participation, and I'll touch on a few others. But then, at section, I believe, section 7, subsection 2, this court is provided with a marking scheme. It is to apply when considering whether administrative action such as this met the test of the Constitution and of the law. I have been shocked in my own examination of the question to find that the National Assembly and Senate reached a mark. The examination mark was equivalent to my Form 2 physics examination, 0 out of 100. That is the figure they found. A self-supporting 0, and I'll proceed to demonstrate the points. Section 11, section 7, subsection 2, I've read out to the court, states that the person who made the decision, and this is one of the criteria that the court is to look at, whether that person was not authorized to do so by the empowering provision. Now, you've been told, and as I've pointed out here, the respondents make the point that the president was only acting as a matter of abundant caution. Now, it is not in dispute, I think it is common ground between us, that the IEBC did not have commissioners or a chairperson. In 2025, the Supreme Court of Kenya handed down a decision. It is part of our list of authorities. It's called IEBC versus the Attorney General, 2025. At paragraph 62, this is what they say. It is uncontested and indeed a matter of public record that at the time of filing of the present reference, IEBC was not fully constituted following the exit of its previous commissioners. There was at the time no indication as to when new commissioners would be appointed. As such, the commission remained for all practical and constitutional purposes incapable of discharging functions that by law require the participation, deliberation, or approval of a properly constituted commission in accordance with Article 251 and 252 of the Constitution. That is a binding decision on this court, and if there were any doubt as to whether the president was actually required by law to do this, or whether he was actually acting as a matter of abundant caution, as it states, I call the court's attention to Article 88 of the Constitution of Kenya, the provisions of the IEBC, the Elections Act, as regards what a nomination is, and with particular attention to the definition of the word nomination. Amongst the other things, the Speaker of the National Assembly had no authority to approve a motion that was based on a law that was declared unconstitutional, because it cannot be a high offense. It cannot be a violation of anything. You cannot violate that which does not exist. That is amenable to review by this court. One of the other tests is whether the decision was made in excess of jurisdiction or power conferred under any written law. Now, the Senate, as senior counsel here said, worked with ungodly speed in impeaching the first petitioner before you here this afternoon. But apart from that, as regards the appointment of a replacement candidate, the Constitution has 74 days within which this decision could be made. 74. It was made at night, within less than 24 hours. So this kind of, there was no power to act with such ungodly haste when you are allowed 74 days to take your decision. Now, the speakers of both the National Assembly and the Senate, as my good friend Elisha Ongoya said here earlier, were beneficiaries and signatories of shareholder agreements which have been placed before you, which formed the basis of grounds 1, 5, and 6 of the impeachment motion. One of the fundamental rules of natural justice is that you cannot sit in judgment of your own cause. They were sitting in judgment of a cause in which they were not only beneficiaries. In the case of the National Assembly Speaker, who I have tremendous regard for, he was a signatory. As senior counsel here said this morning, the replacement, Honorable Kithure Kindiki, professor, a man I have a lot of regard for as well, was the witness of those agreements. The President of the Republic of Kenya signed and bound himself to those documents. And it's important to understand that these documents were not being done as a matter of abundant caution or as a matter of political games. The Political Parties Act requires a coalition agreement to be the foundational document for a coalition. So the Kenya Kwanza government is founded on the basis of these shareholder agreements. And when the deputy president, elected on the basis of those shareholder agreements, insists that those agreements must be complied with, he's called a tribalist and he's impeached. As Jesus would say, first take the log from your own eye. Impeach yourself as the government first for basing your government on a tribal agreement. Then get rid of your deputy president. Now, the National Assembly was scheduled to vote for the nominee to replace the petitioner before the Senate had voted. Again, senior counsel spoke to that, and I won't say much more. But what I will say is that last year, the High Court handed a decision, and I believe this was a 3 or 4 or 5 bench decision, and it's part of our list of authorities, in a case called Njiro and 11 others versus Kenya Kwanza Coalition and 18 others. It's part of our bundle of authorities. And this is what they said at paragraph 489 of their decision. We hold and find that the simultaneous holding of the position of Speaker with that of the leader of a political party and the leadership positions in the ruling political coalition, as is the case with the current National Assembly Speaker, Honorable Moses Wetangula, who is the leader of Ford Kenya and a holder of key position in Kenya Kwanza Coalition, reasonably evokes appearance of bias. And I say this because bias is one of the tests Section 7 of the Fair Administrative Action requires you to look at. And I continue. And undermines his neutrality role as the Speaker of the National Assembly and the independence of Parliament as the symbol of democracy, negatively impacting on our democratic standards as envisaged by the rule of law, principle, and Article 10(2)(a) of the Constitution. And this is what they say. This dual role is unlawful and unconstitutional. I am aware that the National Assembly sought to stay that decision, and that attempt to stay was rejected by the Court of Appeal. There's a decision available on the Kenya Law website. And so, where you have a court decision stating that the referee, the man conducting this impeachment, the man issuing the decision, the man reviewing the motion is biased, is a violation of the rules of natural justice. One of the decisions we have submitted before you, and my good friend Mr. Dudley is a bit more eloquent on pulling them out of his head quickly. The court has said that any decision emanating from a decision maker in violation of the rules of natural justice is not a decision. Now, when you look at, Articles 95 and 96 of the Constitution, the process of impeachment begins or is initiated in the National Assembly. Article 96 then uses some very interesting words and states that the role of the Senate is to consider and deliberate, not on the motion, on the resolution. Those are the exact words of Article 96. And so a resolution emanating from a process shepherded, led by an individual who has been found to be biased is no decision at all. Now, the person who, this is one of the other criteria that the court is to look at, whether the person who made the decision denied the person to whom the administrative action or decision relates a reasonable opportunity to state the person's case. It is important, while looking at this particular question, to examine, according to the first petitioner, where his problems began. I call the court's attention to paragraph 65 of his further amended petition, in which he states that his problems emanated from exercise of his freedom of expression, Article 33, following demonstrations that led to the unprecedented in Kenya's history occupation of parliament by the citizens of Kenya. That is paragraph 65 of his petition. And the reason citizens of Kenya, who called themselves Gen Z, occupied parliament was that they said they were not being heard. Their participation was not meaningful, and the only solution they could find was to occupy the August House. That is the beginning of this problem. And so when Parliament embarks on a public participation process, it is incumbent on it to first advise itself of this history, that this man has been impeached because he made a statement in support of people who occupied Parliament. And so what do? And they concede public participation is necessary. My good friend Mr. Swanya will come and address us a bit more on this, but they give Kenyans 2 days to give public participation. When this court retires to look at the report, because what they did, they then collated, they issued forms. These forms had no serial number. These forms had no way of being verified whether these are Kenyans filling them or not. These were just forms that were distributed all over the place. But they then form a report. And when you look at the executive summary of this report, they say that they received 200,000 responses from the whole country. I did a bit of mathematics. 200,000 people as a function of the 14 million people who voted for the first petitioner and his president comes to 0.014 of the voters. Those are the people who participated. Now, I did a bit of maths in A-level. When you round off 4, it becomes 0. When you round off 1, it becomes 0. So there was 0 public participation, mathematically. It's that simple. 200,000 people out of 14 million is 0. A bit like the result I'm about to give you here on account of their compliance with the law. So you have 0%, and these are figures they themselves have given. In the executive summary, they list 10 problems they had with this public participation. They say there was very poor turnout. In one case, I think it was somewhere in KU, 168% people turned out to give their opinion. 68% spirits showed up to give their views in one particular case. And an order was actually issued against this process on that account. They then, in this form, list the allegations against the Deputy President. This is the National Assembly. But then don't give the people what the Deputy President's responses are. And this is not an idle issue I'm raising here, because, as I stated, and under the Fair Administrative Action Act, Section 5, they must give the public the opportunity to consider all relevant material. All relevant material cannot include the plaint, but not the defense. That was a fundamental dereliction under Article 50 and under the Fair Administrative Action Act. They then say, based on these forms of theirs, that from the entire country, all 50 million of us, they received 8 written memorandum. 8. There are 41 petitioners before you this morning. There are more petitioners here than the number of memorandum they received. 8 of them. 1 per province. Kenya used to have 8 provinces. So again, on average, we got 1 memorandum per province of Kenya. That is what we call insufficient, inadequate, unreasonable, unlawful, unconstitutional. One of the other criteria the court is to look into is, and I think I should point out at this point here again, reasonable opportunity of being heard, which we'll find is one of the criteria. I won't say much about it. Senior counsel has dwelt at length about it. The Senate is informed that the deputy president is unwell. They even ask senior counsel, it's part of the Hansard, to convey quick recovery to him. It's actually there. They tell him, go tell him to recover quickly. Pray for him. They then say, but while you're praying for him, we will proceed here to hang him as you're praying for him. This is what they did. Now, how are we ever going to face Kenyans? By telling them this is what a fair hearing in Kenya looks like. As we are praying for you, we are slaughtering you here. We are praying for you with one hand, slaughtering you with the left. How are we ever going to face Kenyans and tell them that is the kind of justice we practice in this country? How are we ever going to tell them that is what Article 50 as regards a fair hearing means? One of the other criteria is that did the decision maker omit or fail to take into account a critical issue, or did they omit a condition prescribing the power they are to follow? My good friend, Mr. Dudley here again, has talked about the Senate proceeding to vote without appointing a special committee. The court has enough material on that. But the courts, and I say so with tremendous respect, will also have time to look at what the Supreme Court said as regards this committee. It said, we recommend the committee route as opposed to this lynching. The words lynching came from them there. Mob justice, goon justice. They said, do a committee. You'll have time to look at that. I've said they did not conduct a constitutionally compliant public participation exercise. And as I said, it's required not only by the law, Articles 10, Article 118, Section 5 of the Fair Administrative Action Act. But again, my lords and your ladyship will have time to look at the BAT case, again, the Supreme Court case, that gave the 8 or 10 criteria that are to be looked into in examining whether public participation was properly carried out or not. Among the other criteria that the court is to look into, again, from the same Section 7, is whether the administrator failed to take into account relevant considerations and took its action or made the decision in bad faith. Did they consider everything they ought to have? I have a long list of things here, and I won't spend any narration on them. One, they did not take into account the Wambora Court of Appeal principles on the threshold test for impeachment. That is where the threshold test was made. They did not take into account the Sonko Supreme Court case principles on the need for a special committee. They did not take into account the BAT Supreme Court case principles on public participation. They did not take into account the Onyango Olo Court of Appeal case principles on fair hearing, and in particular, what is adequate time given the circumstances. At this point, I should point out, when the Supreme Court is determining whether to annul or uphold the president's election, it normally has 14 days. It normally gives a summary judgment and then reserves reasons for many months later, again, because there just isn't sufficient time. And so, why the National Assembly and the Supreme Court in 2022, in its judgment, actually said we ought to amend the Constitution to provide for more time, you know? Now, why the National Assembly, which has been asked this, and in fact, in 2022, the Supreme Court said this judgment should be served on the National Assembly for them to remedy this question. Both National Assembly and Senate did not take into account Article 50 on the fair hearing requirements. They did not take into account Article 94(4) of the Constitution, which requires them to protect the Constitution and promote the democratic governance of the Republic. I've already cited Section 5 of the Fair Administrative Action Act and other provisions of that act. The resolution by the National Assembly adopting these allegations, which concerned spurious, frivolous, vexatious matters about the first petitioner's family matters, which had been dealt with by a succession court, which was the subject of rulings by the family division, were thrown in just for the heck of it to harass the man, and were designed to violate his rights under Article 31C, which protects every citizen from having information relating to their family or private affairs unnecessarily required or revealed. And in the fullness of time, you will find the Senate actually refused to uphold this ground. The ground had been put there purely to embarrass him, to embarrass his family, to embarrass his supporters, to harass the man. That cannot be a proper motive. That is an improper motive by this party. They failed to consider that the DP, and again, this is the Alai case. My good friend, Mr. Dudley, referred it to the Alai case. In the Alai case, the court said, and there'll be another case I'll be reading out here for you shortly, called Ferdinand Waitito, that you are free to express your opinion. And so, as I said, the first petitioner begins at paragraph 65 by saying all his problems are because he spoke about the manner in which his government had mismanaged the demonstrations by these young people called the Gen Z. Now, we are about to compensate them for shooting and killing them. Now, this will be the first judicial decision that will provide guidance on the interplay. This is an important one because it keeps being repeated, and my learned friends here have paragraphs upon it in their submissions. The interplay between hate speech and incitement, which is under sections 13 and 62 of the National Cohesion Act, vis-a-vis the freedom of expression under Article 33, the political rights at Article 38(3)(c), and the rights of all citizens, including political leaders, to advocate for and protect, express ethnic rights identified in the Constitution. I say ethnic rights with that reason. The first petitioner is accused of stirring hatred, potentially inciting people, because he used the word Mount Kenya. The little geography I learned, Mount Kenya is a rock in the middle of Kenya. It is not a tribe. It's a stone in the middle of Kenya from which we got our name as a republic. Even if you are to count the counties that surround it, they constitute people from every corner of Kenya. They don't have one tribe. He didn't use a tribe. He said Mount Kenya. Mount Kenya is a rock. He can talk about a rock. Number two, even if he was talking about ethnicity, Articles 21, 27, 63, 90, 91, 100, 130, 232, 241, 246, 250, and a myriad of statutory provisions that I could bring here, all talk about ethnicity as a constitutional principle worth defending, worth being held to account for, worth advocating. All of those mention the word. In fact, I found that the word ethnicity appears more times than the word economy. Economy appears twice. Ethnicity 11 times. So, how can you be accused of speaking of an issue the Constitution spent 11 articles talking about? But even more important, in 2016, the late Justice Louis Onguto had occasion to consider a case I have circulated to my colleagues this morning after I got their submissions, and I think I have given the court, my good friend Mr. Njomo, had the court's copies. But this is the case of Ferdinand Dongo Waitito, also known as Babayao, and 4 others, versus the Attorney General. It's reported. This is what Judge such as those about to be made by the respondents, and this is what it says. The Constitution allows every person to picket, demonstrate, assemble, and present petitions. Picketing and demonstrations themselves invite the right to express opinion. The opinions may be controversial. The opinions may appear contrary to the law. Appear contrary to the law. This is Judge Yombutu saying this. The opinions may not find favor with others. Yet, the Constitution anticipates and expects that such unpopular opinions, howsoever expressed, be respected. Now, not all of us can speak as good English as my good friend Dudley. or my good friend Professor Ojiambo here. But you're free to express yourself as you will. If you read a document that talked about shareholders, that is what you say when you go to the public. Why would you be vilified and impeached from ever holding public office for reading a document that founded a government? On what basis? He then says, even if they invite disagreements and counter demonstrations, this is the first time, I think it's good, Kenyans would know, counter demonstrations are allowed, not just demonstrations, even counter. The Constitution thus far declines to stifle even the most unpopular view unless it is intended to incite persons to violence, propagate hate speech, is propaganda for war, or advocates hatred through ethnic incitement. When you retire to look at the provisions of the National Cohesion Act, sections 13 and 62, that are the basis of these frivolous grounds, they say the critical function is what my professor, Gideon Muigai of criminal law, used to tell us was called the mens rea, the intention. Did you have the intention to cause hatred and incitement? You cannot have had the intention when the document you are reading is the basis for the government that was formed. You cannot incite people with the government. You reward them with a thing nowadays called power and economic empowerment. You do not incite them. You can't cause hatred by talking about a government that was elected by people on the basis of a document. And so the DP's public references as regards these shareholders cannot be tantamount to hate speech. They cannot. This is public speaking, as I've just stated. And I should state here, the case of Ferdinand Ndung'u Waitito and the four others, among the four others are the current leader of majority in the National Assembly. So he knows this. When they were considering these grounds, he was aware of this decision because he was one of the petitioners. And they were told, no, you can't stop people from talking. Now, but then, they then went to the Supreme Court, the Court of Appeal, sorry. They tried to overturn this decision, and the Court of Appeal rejected that attempt. So this decision, I'm reading Ferdinand Waitito, has been upheld as well by the Court of Appeal. There are many instances where one would be said to have caused the hate speech or incited people or have said things that were unpopular. The first petitioner is accused of having spoken against the National Intelligence Service. When you retire to review the material before you, this is the Senate Hansard, and this is ground number 9, which you'll find at page 64. There is an interesting exchange where my good friend Ekomas Mutuse is being interviewed, is being cross-examined on the question of the NIS. And he's directed to a case where the current president, who, while deputy president, also very harshly criticized the NIS. So criticizing the NIS has not started now. In fact, the current first petitioner, who was the deputy president, should be accused of being a good student of his boss, the former deputy president, who's currently the president, because he too also criticized the NIS. So, and the NIS, as with any other state organ, can and should be criticized. No one is beyond criticism so long as it is well-founded, as turned out in this case. It is made politely. It is stated in good English, relatively good English. Our client spoke some fairly good English. He's a literature graduate. He said nice things. He said them nicely. Now, they offended the heart. But you know, no one is beyond criticism. One of the other things, I think, and we've stated this in our petition and submission, again, on the question of bias, the National Assembly Deputy Speaker, the 8th respondent, is on record as saying her instructions to execute the impeachment came from a building in Kilimani called State House. And one of the things the court is invited to look at is whether the person exercising this decision acted on the direction of a person or a body not authorized or empowered to give such directions. Now, one of the other issues that this court is asked to look into is whether the administrative action is rationally connected to the information before the administration. Again, as I have said, it cannot have been rationally connected to this decision when among the grounds was a law that did not exist, was issues pending before the succession court was the exercise of freedom of expression under Article 33. I will not repeat the question about the issue, but it's one of the other issues, again, you'll be able to look at. The question of these shareholder agreements, I need not say any more about that. But is the decision unreasonable? The ungodly rush to execute a premeditated decision is unreasonable. A one-day notice to the public to conduct public participation regarding a matter that even this court has said is of great public importance is unreasonable. Conducting public participation in which the public only has access to the impeachment motion, a summary of it, by the way. The evidence was not given to the public. They were just told he has violated Article this, Section this, and Section that. Most lawyers could not tell you, with the most, leave alone the public, other than my good friend Mr. Umtata. No public member can read these sections out of their head. And yet this is what they were given on this document and told, should we impeach this man or not? Passing a resolution based on public participation, as I said, that had 0% of voters who cast the votes in 2022 is unreasonable. One of the other criteria is whether the administrative action or decision is not proportionate to the interests or rights affected, and whether the impugned action or decision violated the legitimate expectations of not only the Deputy President, but the nation at large. Now, the case I cited earlier, which is the 2025 IBC versus AG case, states the following words. Kenya's history is one of executive overreach and institutional compromise. This is what the Supreme Court said last year. And for the avoidance of doubt, Section 12 of the Fair Administrative Action Act states that the act is in addition to and not in derogation of the general principles of common law and of natural justice. Now, as I said, the National Assembly and the Senate violated all known canons of fair hearing and constitutional procedure. Amongst the most harmful things they did was to destroy almost the principle known as the principle of legitimacy. The principle of legitimacy has 3 pillars. Pillar number 1, people must have voices and their voices must count. That's the first pillar of the principle of legitimacy. The second one is that public affairs and the law must be conducted with fairness and justice. That too was violated. And thirdly, that laws and rules must be consistent and applied evenly and predictably. I repeat, the current Deputy President is the witness of these shareholder agreements that led to the impeachment of the Deputy President seated here. The President, the Speaker of the National Assembly, the Speaker of the Senate, all are members of parties that signed and are beneficiaries of this agreement. How can we say the law is being applied equally, fairly, and evenly, even in the limited space of the political players, when one group is treated one way and one individual is treated another way? I want to rest this area of my submissions, and perhaps maybe you should allow me to just read for you, as I found my notes on the provisions of the Elections Act and the IBC Act that deal with the question of nominating a Deputy President. These are Articles 82(1)(b), Article 88(4), the definition of the word nomination at Section 2 of the Elections Act, Section 22 of the Elections Act, and Section 4D of the IEBC Act. I want to close with the following paragraph taken from the decision of the IEBC, versus Attorney General 2025 case. This was a case concerning the delimitation of boundaries, and the Supreme Court of Kenya said as follows. And this is the penultimate paragraph of their judgment. However, before we conclude, we must address a matter that has troubled us. And it is my very, very tremendously humble and respectful request to this court to also be equally troubled by the things that the National Assembly and the Senate did in this matter. The history of Kenya's electoral process, from the findings of the Kriegler Commission after the 2007-2008 post-election crisis, to the litigation around elections culminating in the 2022 presidential election, reveals a consistent theme, one of a deep-seated trust deficit. I beseech this court, do not countenance any further trust deficit based on the things the National Assembly and the Senate did. Trust deficit between Kenyans, the IEBC, and the electoral process. This deficit did not occur by accident. It occurred because of actions like the ones by the National Assembly and the Senate. Rather, it is the product of decades of politicization of the electoral process, relentless attacks on the Commission's independence, and a failure to implement electoral reforms in a good time and in good faith. Leaders exercising delegated authority, such as the National Assembly and the Senate, on behalf of the people under the Constitution, rather than fueling this mistrust for short-term political gain. It appeared last year, 2024, when the impeachment was going on. It seemed that there was a deadline by 20th October. And when I slept, I woke up with a eureka moment. The idea was to have a new deputy president at the holiday. You know, it gripped me. I hadn't seen it before, you know. And so undermining the very institutions they are duty-bound to protect should channel their power and influence toward addressing structural weaknesses, enhancing accountability, and reinforcing public confidence in the impartiality and competence of the IEBC. In this case, I say of decisions by the two bodies before you. Ultimately, the legitimacy, which is why I spent some time talking about the doctrine of legitimacy, and this is what they say. Ultimately, the legitimacy of Kenya's democratic order depends not only on credible institutions, but equally on the fidelity of political actors to the spirit of the Constitution and the sovereignty of the people, which was in question during this impeachment. Unless your ladyship and my lords have any questions for me, I want to thank you for the privilege of your time and attention. I'll rest at that point. I hand over to my senior, Mr. Swanya.
Thank you. I would like to make this comment that repeated issues are coming up in your submissions, and I want us to believe that we have heard most of those issues. If you find that you are bound to repeat what has been said, we want to assure you that it is not necessary.
Thank you. My name is Swanya. I'll address the court on notices. But before I do so, let me cite the Supreme Court, a case on PAT, which says public participation is a constitutional requirement under Article 10 and 118 of the 2010 Constitution. The Supreme Court, in a PAT case, held that public participation and consultation is a living principle that went into the constitutional tenet of the sovereignty of the people. Under Article 10, Sub-Article 1 and 2, as a constitutional principle, public participation binds and it is applied to all aspects of governance. Your Honors, and Lady, I want just to get down to some specifics on public participation. It is designed to ensure accountability, requiring public engagement, rather than just parliamentary approval. In the context of impeachment, it is a remedy of the last resort. This, I think, was mentioned by Senior Counsel Paul Mwite. Therefore, the public participation exercise must meet the following standards, and this is what I wanted to get down to the specifics. One, must be purposeful and meaningful. Must be real and not illusory formality. It is not cosmetically done for Public Relations Act. Should not be undertaken as a matter of just to fulfill a constitutional requirement. The public participation exercise outcome must have quantitative and qualitative components. It is accompanied by reasonable notices and reasonable opportunity. Further, Your Honor, the court tried to highlight what is the components of meaningful and purposeful public participation. It must have clarity of the subject matter of the public, for the public to understand. The structure and process, that's the media of communication, of the participation, participation that are clear and simple to understand and follow. This particularly is the instruments that are used to collect data or to be given to the participants on public participation. They got to be simple, clear, and easy to follow. There must be opportunity of balanced influences from the public in general and commitment to the process. It must be inclusive of effective representation, integrity and transparency of the process, and capacity to engage on the public, including that the public had to be first be sensitized on the subject matter. These are the details that our guidelines the Supreme Court gave on the PAT case. So now let me just get straight to the notices. Before I get to the details of it, let me define what a notice is and a reasonable notice. A notice is a formal information to parties attached or necessary to a judicial process, informing them about the issues they need to know and given an opportunity to respond to them. The courts always will rely on the parties to properly serve notices to the affected parties. A proper notice is regarded to be proper and adequate when it has the following elements. Number one, it must be in writing and indicate the date issued. It must be clear and precise, or state the clear and precise object of the notice. Provide specific venue and duration if necessary. Provide adequate timelines and periods as may be stated in a statute or an agreement. It must refer to a statutory or an agreement or resolutions, and of course must be served. In the case of Battle versus Globe and Mails Limited, 1960, this a Canadian case, the Supreme Court, Ontario, clarified what is agreed, clarified on the reasonable notice, that where there is no agreed timeline in a notice, a reasonable notice kicks in. It is a common law concept that refers to fair amount of time that must be provided for the parties to respond to a matter that concerns them before a decision is arrived. The Lord, I brought this up because we do not have a codified law that guides the impeachment process, which has guidelines on the notices and durations or steps to be taken for an impeachment. And what we have only is what the Supreme Court, in the case of PAT, has given as guidelines. And so one of it is reasonable notice is necessary. And that's why I've referred this case where there's no notice, then automatically a reasonable notice kicks in, and it talks about the timelines. Now let me state also in the case of Robert and Gachagua versus Governor Kiambu County, the court has been clear that arid or poorly publicized processes amount to illusory participation, being a formality incapable of influencing the decision. Therefore, reasonable notice to the 290 constituencies must be understood as notice that is sufficiently served early, widely disseminated, and accompanied by accessible information for realistically enable the citizens to engage. Anything less, particularly involving inordinately compressed timeline, undermines the Constitution standard by denying the public a genuine opportunity to study the issues and be able to formulate a position and present meaningful representation capable of shaping the final decision as in the present case. Your Honors, I now submit on the National Assembly's failure to meet the standard of reasonableness and meaningful engagement. The National Assembly, in their own report, reveals a process that prioritized speed over substance, failing the reasonableness test as follows. The notice ran for only 2 days. That is on 2nd and 3rd October 2024 for the public participation exercise, which was to be held on 4th of October 2024 at a purported initially a designated single venue at the county level. Additionally, the National Assembly report on 3rd and 4th October 2024 stated that they had 40,000 copies of the notice of the special motion were circulated as newspaper pullouts. This begs the question whether the 40,000 copies were adequate for meaningful national public participation, and whether the 2 days were adequate for circulation of the same